Any mentioning?
My lord, I am mentioning one.
My lord, very extreme urgent matter, my lord. My lord, I have my lord, mentioned it is appearing in the mentioned matter heading.
Yes.
My lord, may not be taken up. My lord, may not be taken up.
Take up mentioned matters from 2 p.m. also today.
My lord, 568. My lord, 60 matters are behind. My lord, the auction is going on. My lord, that was the end.
Matters will start at 12 o'clock.
My lord.
After 2 p.m. I have no original side matter today. I'll take up mentioned matters after 2 p.m. also. So please wait for your turn.
My lord, I will bring the other side. If your lordships, my lord, kindly fix at 3 p.m.
Inform the other side. Come, let us see how far I can call.
My lord.
My lord, my matter is my lord, motion appearing every day. Whenever the date fixed for my new taking new motion, 24, 25, 26, like that items.
Not
It is
before.
not reaching. My lord, up to before puja vacation, I file this matter.
After vacation.
Only small matter, my lord.
Tomorrow also
Just
it may not reach. Come back after vacation.
after vacation.
Yes.
I get
Yes.
My lord, only one prayer, my lord. I know, my lord, since my lord, the vacation is ensuing, my lord. My lord, here what has been done by by the Panchayat authority, my lord, without acquiring my land, on my land, a multi-storied building is being constructed by the, my lord, this, my lord, PWD authority, my lord, and completely blocking the free ingress and egress of my lord house.
Mention
My lord.
immediately upon
My
reopening.
lord, can it be listed, my lord? We can try it after. My lord, it is, my lord, only for, my lord,
It will be better
updating.
if you mention and I'll include it in the mentioned matters
My lord.
on reopening. That will be better. Mention immediately upon reopening. I'll
to mention an extension of entry model.
Case study, ATM calculated and notice. See all the stocks of mine. Whereas when I beat the validity, ATM send forward to the MMTTCL for opening the portal. And while filing she wants, this is the type of all documents seized, all household clock will be seized by the ATM, my lord. Whereas my payment is there, that forwarded to the MMTTCL chairman. I have served a notice also. Within 31st December.
Who are the expired lessees?
So in this matter, I have paid the entire my stock. ATM proposed for the payment to open the portal. That is pending. That is why requisition is filed. Due dependency of the requisition is passed over.
Are you mentioning upon notice?
Yes, all.
Mention a
Extension of entry model. Lordship, may I be permitted to mention on extremely urgent
upon
matter?
notice.
Yes, yes, Lord.
My lord, may I permitted to mention a matter? My lord, please to give the matter in today's list, but it is in item number 172. My lord, kindly fix it any day after vacation.
So mention after vacation, it will be fixed.
Lordship, may I
Mentioning it today.
Lordship, may I be permitted to mention one extremely urgent matter? This is regarding a recalling application of your Lordship's order. This order was passed ex parte. So the only difficulty I am facing right now is, Lordship, within the vacation, my construction may be removed. That is the only difficulty I am facing, Lordship.
Order could not have been passed ex parte, number one, because maybe notice was served and you have not appeared.
Yes,
That was the case. So
yes,
please
yes,
do not
Lordship.
say that it was passed ex parte. This court never passes an ex parte order. Number one. Secondly, if it's an unauthorized construction, come back after vacation. No urgency.
I'm mentioning for item number 479, your lordship, here the respondent authorities are filling up the water body, which is under the classification of non-included. They have filled up the water body and started constructing a office god. Now it is in front of the land of the petitioner.
You are mentioning upon notice.
Yeah, notice.
Give the number.
My lord, may I permit to mention, my lord, for upgradation, my lord,
After vacation.
my lord, kindly, my lord, the private respondents are, my lord, the constructed building over the, my lord, the PWD land. That is why, my lord, my ingress
I
and
understand, sir. It's not that urgent. Come back immediately after vacation.
Lordship, may I be permitted to mention on matter yesterday?
Tomorrow is the last day, sir. Please do not mention today.
Lordship, yesterday I mentioned this matter. Lordship dated me to serve and then mention the matter Your Lordship. The NKDA is the authority. They have constructing on my land marketplace, Your Lordship. And Your Lordship, they have completely blocked the ingress and egress, Lordship.
Immediately upon reopening.
Lordship, kindly take it up today, Lordship. Tomorrow, Lordship, kindly, Lordship. I've served the notice. There's no private respondent, Lordship.
Not
kindly-
possible, sir. Come back.
Lordship,
after
5 minute
immediately
matter,
reopen.
Lordship. Kindly give me some.
Emergency.
Lordship, there is urgency, Lordship.
Not bargain with the court, sir.
Lordship, kindly hear my urgency.
Yes.
My lord, there is some urgency and my lord, it cannot be wait after vacation. My lord, that is
Have you?
my lord, 502 day before. Yes, no, my lord.
Lordship, I've mentioned, Lordship,
It's called the
Lordship, kindly.
dispute.
But may I be permitted to mention one matter, my lord? May I be permitted? But
Yes.
may I be permitted? But on 12, I mentioned the matter for correction of order, and your lordship was pleased to allow this by mentioning and direct the matter to appear in the list. But my lord, the matter is appearing since on persuasion, I came to know that the matter file has gone to the record department. And since if you unless and until your lordship court's direction or requisition
It's a
Lordship?
disposed matter.
disposed of matter, unless and until requisition is made to the record department, file is not coming, my lord.
So will you
Only
remind,
one.
will you remind me immediately upon reopening? Because file may not come in a day. Yes.
Lordship, I'll again mention, madam. Grateful, lordship. Great.
Lordship, the construction might be completed. Lordship, kindly takes up the matter tomorrow. Lordship, I've served the notice. Lordship. Kindly, Lordship.
Give the number, but I do not know whether it can be taken up, sir. If you're insisting, if you're happy with giving the slip, let it be. Yes.
My lord, I am for the petitioner, my lord. My lord, my
I
client, my
on
lord,
behalf of the state.
Doesn't want
I
to
am for
proceed.
the respondent ADP.
let the, my lord, this instruction be kept with the record.
Yes. Learned counsel for the petitioner submits that the petitioner does not intend to proceed with the matter any further. Paragraph written instructions submitted on behalf of the petitioner is taken on record. Paragraph in view of the above, the petitioner being the case has such for non-prosecution. There shall however be no orders to cause.
Deeply.
Deeply applied, my lord.
Deeply.
Next matter.
Item number 2.
Item number 2, my lord, I mentioned the matter, my lord, for non-prosecution. My advocate on record is not here, along with the loan.
Advocate on record.
Is not here, my lord, along with the letter, my lord.
So on your submission, shall I do it
My
or?
lord, kindly does not, my lord. Kindly, my lord, keeps it tomorrow, my lord. I'll my lord, keep it with me. I'll keep the letter, my lord, with me. Lord, I'm very sorry, state.
Not today.
I apologize, my lord.
Next.
Item number 3. Item number 3, Lordship, I don't understand why this matter appeared because Lordship was pleased, Lordship was pleased to dispose of this matter by an order dated 12th of December.
আপনারা mention করেননি?
I think it has been sent by the department. Oh, as report is not found. The report submitted by the respondents is not on record. That's why it has come back from the department. You have not submitted the report. Yes.
Report not found.
Please check. Please find out. I think the report is lying with you. It has been recorded that it is on
All right,
record.
Lordship.
That's why it has been sent back. Please inform my court officer. এটা রিপোর্টটা উনি দেবেন।
Not to not to থাক।
হ্যাঁ?
Not to রিপোর্টটা পেলে কালকে হবে নাকি? No order need to pass.
এটা আলাদা রাখা থাক। Please inform in course of today.
রিপোর্টটা দিয়ে দেবেন।
Grateful, Lordship.
Next.
Item number 4.
I am for the petitioner.
Yes.
Correction on because Lokhi Kantur card I have added already party my lord. Your lordship direction to add 9. Respondent number 9.
Yes.
Already Lokhi Kantur have assistant engineer Lokhi from the highway. But it was join over. Already respondent number 2 that is already.
Who is appearing for the respondents?
Respondent number 9 mind. Kindly see. Page 3 mind. Assistant Engineer Lokkikantapur Highway, Subdivision PW Road, Karbala, Post Office Dokshine, PS Mandira Bajar, DC South.
The matter has come up under the heading to be mentioned at the instance of the petitioner. Paragraph inadvertent error has crept into the order passed on 12 December 2023. In the third paragraph of the order, the Assistant Engineer, Public Works Directorate Subdivision, Joynagar PWD, be read as the Assistant Engineer, Lokkikantapur Highway Subdivision, PW within bracket Roads Department, Karbala.
Post Office Dakshin Bishnapur, PS Mandira Bajar.
Karbala, police station. Police station is
Mandira Bajar.
Mondir Bajar. Mondir Bajar.
PS
Post office Dakshin Bishnupur. তারপরে ডিস্ট্রিক্ট আছে আন্ডার ডায়মন্ড হারবার এই অবধি বাদ যাবে জয়নগর পিডব্লিউডি আন্ডার ডায়মন্ড হারবার সাবডিভিশন সাউথ বিষ্ণুপুর এই অবধি বাদ যাবে ডিস্ট্রিক্ট থেকে থাকবে paragraph the department is directed to incorporate necessary correction accordingly. This order be treated as part of the order passed on 12th December 2023. Urgent certified website copy. Next.
নামটা কোথায় লিখেছে যেটা হবে এটা রেসপন্ড নাম্বার 9 লিখেছে
Item number 5.
সেম মাইন্ডার এই
Slow.
It was also same mind.
Same order.
Malat middle of the item 9 or item 10. Middle of the question on the second page. What are the second page? Direction item 10. Respond number 10. Or it will be respond number 9. Middle page.
So choice.
Order page middle portion, right? Second page.
It will be 10 because 9 till 9 it is there. This should be 10.
Yes, 10 will direct it. But my middle of the portion is 9 that.
No.
Middle of the
Second page.
second.
It has been corrected as 10.
Yes. Second page correct. Already corrected.
10 for us.
Second page 10.
আছে অলরেডি কারেক্টেড কারেক্ট করা আছে এখানে
Next.
No. Item number 5.
5 হয়ে গেল
5. Item number
6.
Well, I am for the petitioner in this matter, Mal.
yes.
I appear for the case.
Mal, this is my affidavit
appear
of
for the
service
corporation.
as well as Mal, to be mentioned, Mal, I have mentioned the matter for urgency, Mal. This is a matter had in the NH authority without giving me any notice or hearing anything. They are Mal earmarked with the yellow color in my pillar, which has been constructed upon getting sanction plan from the Howrah Municipal Authority, as well as the KMDA also give the sanction for development plan. The NH authority, what?
I think will be port number 24.
No.
This is corporation matter, plan, sanction plan matter. I don't know how can he come here.
No, my lord. What happens, my lord, in this matter? Why I am filing this matter before your lordships? My lord, the thing remains that corporation did not give me any objection, or corporation cannot come to give me any no stop work notice. What happens? The NH authority suddenly come to my house and say that this house should be demolished. It is our property. I have gone to the LA acquisition collector. I have annexed that document. Your lordship kindly come to page 12. My lord, page 12, annexure P1, it was clearly stated that the LA collector acquired 1 kata, 13 chotak, 18 square feet of land. Thereafter, my lord, I have got permission. After development agreement, I have got permission from the KMD authority.
Beyond that land.
Yes, my lord. Because, my lord, total land is, my lord, 5 kata something. And, my lord, I have constructed
Part
with,
has been acquired.
my lord, 1 kata, 3 chotak, 18 square feet acquired. Thereafter, some, my lord, as per the municipal rules and KMD rules, I, my lord, after FAR, I raise con. Now the NH authority has come and say that this is our portion. I should demolish the thing. And verbally they have said that. No notice,
lord,
nothing else.
MDA never grants sanction. What sort of permission he has taken?
No. Sanction means one development plan. My lord, I have the.
My lord,
He has
this
not disclosed the document.
my lord, the subject plot,
No,
my
no,
lord,
no,
the
no,
RS plot
no, no.
number 58, jail number 1,
Clearance.
Mozam Shipur, my lord, has recent lordship acquired by the National Highways lordship under the National Highways Act. In the month of January 2022, lordship, the 3A notification has been published.
Entire plot?
Yes, my lord, the subject plot, my lord, the RS plot number, my lord, entire, my lord, I have these 3D documents, my lord. In the month of January 2022, my lord, the 3A publication has been served, lordship,
I've
and
got-
thereafter, 24th January 2022, my lord, in 2 local newspapers, it has been declared. After that, my lord, the 3D, 15th June 2022, my lord, there has been publications, and it has been vested with the central government, lordship. My lord, how my learned friends, without any notice, my lord, how my learned friends said, I don't know, my lord, because it has been clearly mentioned in 3D.
I don't know, my lord, what my learned friend said. Without giving any acquisition notice, my lord, they have taken away my right away.
It is a publication. It has been published in the local newspapers.
There should be some acquisition proceeding. Compensation should be given.
And my lord, and it has been clearly mentioned that it is a government land, my lord.
My lord, I went to the office of the LA collector. LA collector says that we have not acquisition any further. There is.
LA collector will not know about this.
My lord, then they are.
But it has acquired.
Yes, my lord, they can do it, but
My lord, as per
right to.
section 3D
My lord,
code
if it is
of this
article
national, even
300A,
the court cannot intervene. It has been mentioned in the statute as per subsection 4 of section 3D.
my lord, what I am.
When the
on,
land
my
has
lord,
been clearly
if
vested.
my property has been taken away, then I should be informed.
Notification has been served. This is
No, my lord.
My lord, lordship, it is in the public domain, my lord.
My lord, let them so that they have given notice to the landowner.
Let us see 3A1.
And my lord, my permission has been given. My sanction plan has been taken away. My lord, on 21.
Shantanu?
After that,
National Highways Act দিন কিছু তো খুঁজে পাওয়া যায় না।
আমার কাছে আছে like
The copy is there.
No, there should be a book.
my lord, then my lord, kindly এটা যদি সাহেবকে দিন।
National Highways. All
There
the
is a
books are there
copy.
but not found.
my lord, whether they have taken away my right to my lord, property,
3D তো বলছি করব।
which has been guaranteed under Article 300
My lord,
of the
kindly come, lordship,
Constitution.
after 3A, my lord. The 3D's lordship clearly mentioned vested with the central government and the court, even the court cannot interfere.
Without any proceeding. My lord, whether there is any acquisition
Then, lordship,
proceeding
then
there.
he has to challenge the highness of this act, my lord, if that be so. On 24th
lordship, that
January, it has been published in 2 local newspapers. One is Times of India, another is HON'BLE. 2022. They very recently acquired.
And I have got the sanction plan from KMDA.
The publication under section 3A.
My lord, there should be, my lord, I
should
know,
be
my
the-
lord, 3A, 3B, 3C, 3D, everything I know, but what about the statute? I don't know about that my client doesn't know even any sort of information regarding their acquisition. My lord, your lordship kindly.
Publication is sufficient. No individual information is necessary under the Act. It
Well,
was
then-
published in daily newspaper.
Then
2 daily
what should be
newspapers.
now, what should be the compensation in respect of that property?
Yes,
My lord,
what
your lord,
steps have you taken for the compensation?
My lord, subject to lordship's correction, lordship, there is a government land, lordship. It has been transferred, lordship,
no,
through the
no, no.
notification. And if that,
No,
be
no,
lordship,
no.
if any
How
lordship,
can
that
it
should
be
be
government
answering
land?
the
Your lord-
state, my lord.
My
I am
lord,
competent
there
to be the
I-
answerable respondent here.
There I,
Regarding the lordship, the acquisition,
there
it
I
has-
shall join issue, my lord.
it has been vested,
How
my
can
lord.
it
And
be-
lordship kindly see it is a government land. Lordship kindly
no,
see the
no.
3D
My lord,
notification.
it cannot be a
It is a
government land.
government
If your lordship,
Then lordship challenge.
how can it be government land? If it is in the LR record,
Mention, lordship,
my lord,
through these notifications, lordship. If that
My
means
lord-
the subject plot is
my lord,
RS
in the
plot number
LR
58.
record, it has been said that this land is of mine. And in the Howrah Municipal Corporation, my lord, in the mutation sheet assessment book, also my name is there. How can it be government land? What my learned friend said.
Now they cannot
I am
say
saying
that
on the basis of the
What
document.
my learned friend
it
said.
cannot be a government
My lord,
land.
this is
Yes,
the,
it is a government
my
land.
lord, the NH authority, my lord, I have already, my lord, talked with the LA collector.
Government bus
They
to
said
non-agriculture
the
area.
NH authority, without giving information to the LA collector, without taking into
Yes.
courts of any
That-
compensation, they have taken out.
The acquisition
Your
process.
lordship,
That is the publication.
your lordship, I have come with
NHIA
this,
proceedings are
your lordship kindly direct them not to demolish the house.
This plot-
1 week after vacation, your lordship fix the matter. In the meantime, my lord, let them show, my lord. I shall also come with, my lord, whether what my landed friend said.
3D notifications, my lord, this has been
Whether it is
mentioned.
whether it is a vested land or not, my lord, I will
Understand.
show you, lord.
Do you say that it is government land?
Yes,
handed
well,
over to
RS,
you?
lordship, that is the RS plot number, lordship, that is the subject plot of this writ petition. This RS plot number 58. Lordship, see the government within bracket Bastu, non-agriculture, 0.0336.
My lord, it is their publication.
That is a hectares, lordship. That has been regarding this plot. And it has been mentioned a government land.
No, my lord,
That the owner of the state government.
The land has been acquired, that is admitted.
1
Lordship, here, lordship, that is mentioned, lordship, the RS plot number 58. It is a government land, my lord. And it has been vested from the central government, my lord. And it is free from all kind of encumbrances now. And as per section, lordship, subsection 4 of 3D, if your lordship kindly allow me, lordship, to peruse this section, it has been mentioned even the court cannot interfere. Lordship,
Where is
kindly
that
allow
section?
me.
My lord,
Yes.
my lord, in
My
your
lord,
lordship
the
kindly go
section-
through it, then my
subsection
lord,
4.
I shall add.
Subsection
this
4 of 3D, my lord. Any declaration made by the central government under subsection 1 shall not be called in question in any court or by any other authority.
Declaration is not being called in question.
My lord, the 3D lordship, the 3D notification has been clearly mentioned this plot number, my lord. This, as per the 3D notification, my lord, I am submitting.
To say that any acquisition under the Highways
As
Act,
per
the
lordship,
court cannot interfere.
lordship, after the 3D notification, lordship, regarding the question of compensation.
The report annexing all the documents.
My lord, I am ready with this.
Since
sir.
then,
I am-
let there be a status.
No, my lord, lordship, kindly, lordship. This lordship,
No,
my
lord. No, my lord.
submissions, my lord, kindly record it, my
Otherwise,
lord.
if my
Without
property
this,
has been
my lord,
gone,
this
they will
3D,
do
my lord,
everything
this
and
3D
everything.
notification, my lord, kindly recorded. As per this
My lord, then, my lord,
notification,
the
my lord,
matter will
this has been
become
mentioned.
infractuous.
As per this plot, my lord, this
My
has been
lord,
vested.
Come back immediately after vacation. Since the vacation is starting almost, let there be an order of status quo.
I'm grateful.
My lord, in that case, my lord, kindly recorded my entire 3D notifications part, my lord. Otherwise, my lord, my case will not be lordship in go by, my lord. Because as per these 3D notifications, my lord, I am with this 3D notification. After the 3D notification, my lord, this has been clearly vested with the central government.
One submission. Since the notification has been published, although we are not affected to assist this honorable court, my lord, procedure is 3C. Since it was complied with,
3C, no objection was filed.
no objection.
After that, my lord, the 3D is there.
3D declaration. Then next recourse lies, my lord, regarding compensation 5G. He can resort to that. So long
After this-
before the notification was published and he raised no objection, and under the statute.
And my lord,
that
several
cannot be
judgments
said to
is
be
there, my lord.
invalid
If that
on the-
be
on
so.
the prima facie side.
My lord, may I say
3D
one thing?
notification, my lord, that.
My lord, may I say one thing, my lord? KMDA give me, I have already handed over the permission of the KMDA. In 2021, KMDA give me, your lordship kindly back page, my lord, back portion, your lordship.
Yes, permission has not been.
Development permission. Thereafter, it has been sent to the Howrah Municipal Corporation for vetting. They have given me sanction plan which has been annexed with the writ petition. And my lord,
This is for construction.
yes, my
For
lord.
construction.
What happens if if KMDA, now KMDA come with another
That
plea,
the authority could not
We are not coming.
acquire your land after this.
my lord, what I am on, if the land has been vested to the central government, as per my learned friend said,
Upon
so
issuance of 3D, that is her submission.
My lord,
yes, my lord, then it should,
Oh.
my lord, it should be recorded in the BLRO record. Let them
why,
produce
my
that
lord,
it should be
why,
vested.
my lord, why,
Here,
what kind of submission?
My lord,
failure to
how
check
can I know, my lord?
doesn't
My lord, only notification publication, they have published the notification and my right of compensation, right of everything has been gone away.
file objection.
My lord, how can I know, my lord? How can I know?
And according to the law, that is sufficient. 2 local newspapers and a publication. You are supposed to know. There is no provision for individual notice in the law, according to the law.
And my lord, RS 58, what they have shown, my lord, RS 58, they have taken only 1 kata, 3 chata, 80 square feet. After that, they have not taken away.
What is the quantum of land that you have?
5
Lordship,
cut, my
regarding
lord,
lordship,
my
the
land is,
quantum of this case, lordship, that is mentioned in 0.0003642 hectares, lordship, regarding plot number 58. Corresponding the entire thing.
This is plot number 58. Yes, 0.0003642.
Yes, my lord.
So this may not be the entire plot.
Lordship, it is regarding the plot of the writ petitioner. Regarding this, my lord, entire thing, lordship, the total entire plot is, lordship, mentioned in the 3D notifications, my lord. Regarding, lordship, the land of
my lord,
0.45.
may I hand it over to
Yes,
take this, my lord?
and lordship, in the 3D notification, it has been mentioned the local 2 newspapers that has been published in 24th January.
The petitioner
24th
claims to
January?
be holding 3 kathas, 3 chotaks, and 9 square feet. After the acquisition, was 1 kata, 30 chotaks, and odd. That is admitted. The
Yes.
remaining 3 chotaks, 3 kathas, and odd,
Yes.
the petitioner claims to hold. So whether this part is within and demarcation is necessary before
My lord,
demolition.
regarding the demarcation,
up-
lordship, at this moment land has been vested, my lord. Regarding, lordship, the coercive action.
Portion of the plot has been vested. Not
Yes,
the entire
lordship, the
plot.
portion of the plot regarding, lordship,
Which is the portion that you have vested? Please show me.
lordship, lordship, regarding,
Entire plot has not been vested.
lordship, the total, lordship, I
Exact
think,
portion that has been vested.
lordship, that is, lordship, 0.35055009.
It may be anywhere in the plot. Where is the demarcation?
Lordship, the plot number is mentioned, lord, because my learned friend,
That's sufficient.
it is mentioned in their writ petition as per paragraph 14. Mention the RS plot number 58.
Please come to paragraph 3 of the writ petition.
Yes, my lord. Yes. Yes, my lord. That is, my lord, the entire thing.
1 kata and odd was earlier acquired.
Yes.
The petitioner is still in possession of 3 katas and odd.
Then, my lord, kindly come to
You
page
have not acquired 3 katas and odd, the entire land. It is only 0.000 something.
0.03634.
Which portion of this 3 katas is this?
My lord,
Please
in
show
this
me.
case, my lord, kindly come to page 14, my lord.
Of
Page 6 of paragraph 14.
yes.
My lord, that it is pertinent to mention here that the National Highways Authority already constructed a service road in their acquired 1 kata, 13 chotak, 18 square feet of land in the RS plot number 58.
Yes, that is beyond the
Yes,
petitioner's
my lord.
plot.
Only, my lord, my submission is regarding the RS plot number regarding this hectare. My submission regarding this.
This is beyond the petitioner's plot. So there will be a status quo in respect of the remaining 3 katas, 3 chotaks, and 9 square feet.
My lord,
Which is in possession of the petitioner, prima facie.
my lord, where is the documents?
Where is your document of acquisition?
Lord, regarding, I have the documents of the entire Mousa, lordship. Regarding this, lordship, the entire 3D notification is there. Regarding the entire Mousa.
Please show me.
Then, lordship, kindly fix the matter on
Your
tomorrow, my lord.
document says it is. You have specified in your document.
Lordship, in 3D notification.
3642. That is not the entire 3
Then,
katas.
my lord, kindly fix the matter tomorrow, my lord, so that I can assist before your lordship. Tomorrow, lordship, I can give you the, if any other things, lordship, I can show you. So that I can take the instruction regarding lordship's query.
Very well, not today. Come back
My
tomorrow.
lord, they do not take any courtship stage till date.
Not today only.
My lord,
Come back tomorrow.
they are coming, my lord, in the night, and my lord, they are demolishing the house. Entire thing will go, my lord. That is my only, my lord, apprehension. they will give the undertaking before the court that they will not take any till the hearing of this.
My lord, only not today, my lord. Tomorrow I will, my lord, show the documents.
Please instruct
My
the
lord.
fact that nothing happens in.
In the meantime, lordship, not will thing happen, my lord.
Grateful. My lord, your lordship kindly record this, my lord. My lord, only, my lord. Only not today, my lord, suffice anything.
Not
Your
today,
lordship
nothing will be recorded.
kindly record.
Next matter. বইটা ফেরত দিন।
Lord, my application, my lord.
Item number 7, petition in this matter.
My lord, I'm the applicant, my lord, the respondent number 7, and I'm the applicant, my lord. This application I have filed only for the purpose of bringing some subsequent events on record. My lord, if your lordship takes my application, my lord, page.
I'm for the petitioner, my lord.
My lord, I had mentioned the matter yesterday and it's come out my instance, my lord. If your lordship takes page 16, my lord.
Yes.
My lord, page 16, this is the order which was passed, my lord, at the first instance. My lord, if I just read through, it is submitted on behalf of the state respondent that the Special Land Acquisition Officer, Purulia, should be added as a party respondent to the writ petition. For proper adjudication of the same, accordingly, liberty is granted to the petitioner to add. My lord, the next paragraph. The petitioners complained that though their land had been requisitioned sometime in 1963, the said land lying vacant without utilization till recently, and the petitioners have been cultivating the said land till date. A meager compensation was received by the predecessors in interest of the petitioners soon after the requisition. The petitioners have alleged that the respond number 7, that is, my lord, my client, WBPDCL, is trying to encroach the property and make construction therein. Some portion of the property has also been transferred in favor of private persons illegally. The respond number 7 and added respond number 9 are directed to file separate reports indicating entire matter, including process of requisition, utilization of property, and possession of the same. Such report be submitted on the next date of hearing upon service of an advance copy upon the petitioners. Let the matter stand over 17 November. Considering the claim of possession of the petitioners in respect of the property and also submission of respond number 7 that the corporation has started raising construction and installing 2 generator units in the land, let there be an order of status quo in respect of possession of property as on this date till disposal of the writ petition. My lord, we have filed a report. The report is also on record with entire details of what the requisition is, compensation paid, and what is the progress. My lord, the writ petitioners have taken no steps in the writ petition. Well, some of the parties it was informed have the petitioners have died, my lord, sometime in March. No progress made so far as getting the writ petition amended. Well, the writ petition was directed to go out of the list. That's where the status is. Now, my lord, what has happened? We, my lord, WBPDCL, we've given raised 2 tenders for the purpose of construction of the solar power plant, 2 10-megawatt solar power plant in this 56 acre of land. The tenders have been awarded. They are going to start construction, my lord, of the boundary wall and the power plant. We wanted to bring that on record. That is going to start immediately. My lord, lest, my lord, someone comes and says, my lord, that there is violation of any order of court, we wanted to come to court and put that on record. That, my lord, there is a third party who we have given a tender only for the purpose of construction. There is no parting with possession, no parting with.
Yes.
My lord, that, my lord, status regarding possession. Possession is mine. Possession is mine. My lord, possession is mine, my lord. Your lordship, I can show establish.
Because then this application was not necessary.
My lord, my application is only for the purpose, not for, my lord, only for that, because we are getting some third parties for the purpose of construction. Your lordship will see the order also.
After the petition is disposed of, not prior to.
Yes.
My lord, will kindly see the third, my lord, your page 17, the order, considering the claim of possession of the petitioners in respect of the property and submission of the respond number 7, that corporation has started raising construction.
Yes.
Construction had started at that point only, my lord, for the power plant. These 2 solar plants, 10-megawatt solar plants, and installing 2 generated lands. Let there be an order of status quo in respect of possession. So possession, I mean, there was no restraint on construction on my part also. Only thing, my lord, if your lordship takes page 45, this is part of the report also, my lord. My lord, this is the notification. My lord, the Ministry of Power on 27th February 2023 has made this resolution, my lord. If your lordship sees clause 2.0, in pursuance of clause 6.45 of tariff Policy 2016, it has been decided that any generating company establishing a coal lignite-based thermal general station and having commercial operation date on the project after 1st April 2023 shall be required to establish renewable energy generating capacity, that is renewable generation obligation for a minimum 40% of the capacity of the coal lignite based thermal generating station, or procure and supply renewable energy equivalent to such capacity. That is why the urgency, my lord, on our part right now. This was already in progress, but this had to, and my lord, if your lordship takes clause 3.0, a coal lignite based thermal generating, 22nd February 2023.
When was the order passed?
21.
21. September 2021.
Yes.
Chosen to take this resolution.
I have not taken, the Ministry of Power has taken.
Never.
Yes.
They are aware that this writ petition is pending.
Writ petition has not been proceeded with also.
This application, I'll
Sorry.
give a specific direction not to carry on. There is no other alternative. And if you are happy with the status quo on possession, let it be. Whoever is in possession
Yes.
will
My
be
lord,
in
I am
possession.
only, my lord,
Because the petitioner claims to be in possession. You cannot
Yes.
create third-party interest in this.
my lord, petitioner in the petition has not shown anything whatsoever.
That
And
is
my
a-
lord, your lordships, my lord, your lordship, my lord, the order your lordship had passed was only with regard to status quo regarding possession.
Yes. So
My lord,
this
there was no order of.
is not necessary at all in that case.
Yes.
If you are confident that you are in possession, you can carry on without violation.
No, they are.
Since you are not confident, you have chosen to come up
My
with
lord,
this court.
my lord, my only point was
The
I am in
gun on the
possession.
shoulder of the court and carry on, which is not
Yes.
possible.
Grateful.
My lord, if your lordship only takes, my lord, two facts, my lord, two facts.
I'll give a restraining order, a specific order, so that nothing can be done in the
My lord,
property.
my application, your lordship will pass that order, my lord.
Yes, absolutely. Upon hearing your submission,
My lord, here, my lord, we have come.
yes, you can. If the that's not an alternative.
My lord, may I only request then in that.
Status quo order, you have chosen to pass a resolution.
My lord, I have not passed, my lord. This is a resolution which has been passed by the Ministry of Power. I am only complying with it. My progress of the
Can
generating
you do that when there's a status quo order with
my lord,
regard to
possession, my lord. I am not disturbing the possession in it. I am in possession.
question of
My
violation?
lord, construction was already going on. All that I'm doing is a third party will be doing the construction and not me. Earlier, I was only carrying out the construction work.
I have to pass a restraining
My
order.
lord, then in that case, my lord, will kindly, my lord, pass over the matter for some time. My senior is also there. Let me, my lord,
Can be passed over, not possible in this court. You have to come back after vacation of office.
my lord, may I request, my lord? My lord, the writ petition, my lord, they are taking no steps. Will kindly, my lord, direct the writ petition to be heard out expeditiously in that case, because we are also stuck, my lord. My lord, we are stuck here, my lord, because we have to carry this out. The writ petition has taken no steps whatsoever, my lord.
Yes.
My lord, will I
may I
kindly
just
see this order, my lord?
action
My lord, kindly see this order of 31st March
Yes.
2023. Kindly see this order, my lord. The petitioner says, my lord, that some parties have expired.
Yes.
Yes, we are taking similar. May I just submit?
Did it also,
Yes, yes. My lord, may I just submit one thing? My lord, 51 years back, this requisition took place. They did nothing for 51 years. Then they started encroaching.
My lord,
may I just
writ
make my
petitioner-
submission? May I
My lord,
just
the
make submission? My lord,
petitioner
I
has
need to
already
disturb
made
my learned
submission.
friend.
My lord,
My lord, may I
this
just,
writ petitioner
may
has
I
my
just
lord
make
no.
my submission, my lord? May kindly, my lord. 51 years, they do nothing. I come before your lordship. Your lordship has categorically recorded in this order. I read that possession is with the petitioners. They cannot claim today the possession is with the authority. Now, my lord, it's a very dangerous proposition. Using the court, now they are inducting the third parties so that we can be disturbed. In the garb of some project, they were aware of it. They have not preferred any application for vacating of this order. Nowhere, nothing. Now the blame is on me that I am not proceeding. I am not doing this or that. Now this is a very dangerous proposition, utilizing the power of the court. Now they're inducting a third party so that they do not face any contempt subsequently. This is the intention behind this application, which has been exposed before your lordship. Now, my lord, my humble prayer, my lord.
Already expressed my mind.
Yes,
My lord,
I'm
I'm
grateful to
telling
your
my
lordship.
senior, my lord.
My lord, lordship has said no third party rights to be created. My lord, there's no restriction on our using the property ourselves.
Application was not necessary.
My lord, to place on record that we are building a solar plant. We are
If
building.
that is placed on record, I have to pass a restraining order so that that is not done till disposal of the writ petition. And if you are confident that that's what exactly I said. If you are confident with your possession, there is no question of violation.
We have filed a report showing the acquisition showing the record of rights in our name.
In the writ petition.
Very well, Lordship.
My lord, kindly take page 14 for once their prayer for. Kindly take the prayer for once.
Lordship, one more thing, my lord. In the writ petition, the last time they had submitted that some of them have died, no steps have been taken
Yes,
for
we are taking steps.
substitution.
Yeah.
And writ petition,
I'm taking steps. I'm telling you,
well,
Lordship,
we have
please-
given our report long back.
That's on
No, my lord.
So, my lord, then in that case, what your lordship was saying, kindly, because this is a public project, this is getting stored, and we have to meet that. Otherwise, the court plant has to shut down because there's a ministry direction that 10% has to be self-generated. So, lordship kindly keeps the writ petition, whatever may it be. My report is there. Kindly keeps it.
What about the application?
Application also, so lordship can keep it that way. Keep it together. Keep it together.
Please take necessary steps.
Yes,
in the
but
meantime.
only one thing, my lord, can you take page 14, their prayer? Whatever is being submitted, it is not in the prayer. The prayer says leave to be granted to the applicants to bring on record the developments subsequent to the passing of the order by the Honorable Court. Now, can they go beyond the prayer and say
No, I'm not
that
asking,
I may be
I'm
allowed
not
to
asking.
proceed with the construction
I'm not.
and that my learned friend had submitted, that we are proceeding?
On record has a far-reaching consequence.
Absolutely, my lord.
Lordship kindly keeps it on the
only one thing, because they are villagers.
reopening. Kindly give a date.
My lord, there are
Lordship,
villagers.
after all, if they have a genuine right, lordship,
Move taken by the authority, I must say.
Yes.
But then difficult.
I'm
lordship
grateful.
that keeps a day.
Job of keeping it on record.
Yes.
construction
Lordship,
cannot be-
This is not, the court may not be misused in this
lordship,
way.
all I am saying is that keep
Yes,
the
my lord,
matter for hearing.
Takes, please,
My lord,
please
yes,
take
I'm
steps
taking
in the
steps, my lord.
meantime.
I can show. I have got the death certificate as well of few. I'm holding this
For the
right now. Now, my lord, the difficulty is there are a number of villagers. Now they have multiple successors. One dies, the other remains. Who becomes the party and all. These are certain. It takes some time because there are lots of villagers.
We've already taken a lot of
I've
time.
taken, yes, my lord. I am give me some
There
time, my
is
lord.
the
I will
law
come back. My lord, I have come back.
law of
Yes,
abatement.
yes, my lord.
Abatement
My lord,
law
we
is
have
there.
exchanged our
Abatement law when
affidavits.
one files.
I'll expect that within
I will.
one week of reopening, you will
1 week
come up
after,
with
I will do that.
steps.
I will do that, my lord. My lord, only one thing, my lord. We have, it is that alleged that we have not taken any steps. The affidavits have been exchanged. Everything I have done. Only, my lord, I'm collecting the documents because from the villages,
There are no affidavit directions. Only
the
report was
affidavits have been
filed.
exchanged.
What report?
Already.
There is no
No,
question
affidavit, we have filed affidavit.
How
on
can you
that.
file opposition to your writ petition?
Yeah, it has been taken into record. Yes, it is taken in the record.
How can you file
Previous,
opposition?
possibly. Yes, yes.
By opposition. Yes, opposition.
My lord, affidavit in reply to the report.
Reply to
as
the
per direction
report.
of the, yes, as per,
It's over.
as exactly. So that I'm showing that it's not that I have not taken any step, my lord. It is only that I'm
is
collecting the
abated then.
documents.
Steps with regard to
I am taking
substitution.
steps, my lord. I'm taking
Because it has
steps.
abated by now.
Absolutely, absolutely.
Yes.
My lord, I'm taking steps. Give me some time so that I can incorporate
So
these
some-
documents.
Within 1 week of the vacation. I'm not recording any order
I will
today,
not
but
bargain
please
with the
do
court. Yes,
that.
my lord.
Matter has gone
My
out
lord,
of place.
kindly consider this application and let them not proceed.
Take it along with the writ petition.
Very well, my lord. In the meantime, no coercive step may be taken by them because they have come with
It is
something.
already ordered.
Yes, my lord. I'm grateful
No
in that.
further order is required.
I'm grateful.
Should be
Can
date.
1 of 2023 লিখুন যে the application shall be taken up for consideration along with the writ petition.
Should any date, my lord, should kindly give a date.
It's out of list, let him come back.
Yes,
Should
grateful to
give a date. If they don't come, we shall proceed. If they
May not, because the abatement has to be
no,
taken
but
care of.
so far, my lord, there are several writ petitioners are still alive. So if some of them die, the writ petition does not.
No,
uh,
but it abates
I have
with
to.
regard to those.
Abatement.
So, well, if they don't take steps, well, how
I'm
will
taking
the
step. I'm taking
lordship has said within 7 days they should.
Let us wait till 7 days after the
Leave to
vacation.
mention.
Let him
Then
Yes,
they
yes.
kindly give leave to kindly give leave to mention. Kindly give us leave
It's
to mention.
always there.
Because after a week, then we shall mention. Well,
mention even without leave, Mr. That
then
is not necessary.
lordship will remember if your lordship's order. I show my lordship.
Without leave, this application has
come back
come.
and mention that.
Yes, I'm grateful to your lordship. Extremely grateful.
Next one.
Item number 8.
The 3 applications are my lord pending before your lordship. Data service to
What are these applications?
my lord, copy has already been served. One was my lord for substitution. The other,
1 and 2 has been dismissed for default already.
yes, my lord. One was for substitution, 2 was for condonation of delay, my lord, in preferring the substitution. The third one is my lord
But they
subsequent
were
to,
also dismissed.
yes,
So
my
there's no
lord.
question of restoration of anything now.
Well,
There
restoration of,
should be a limit to default, isn't it?
well, that is, well,
You default in the writ petition, 2 applications were filed, you default in that also.
restored, my lord, dismissed for default once, my lord.
Yes, so you filed 2 applications after that, which
Substitute.
were also dismissed for default.
My lord, substitution and my lord for setting, my lord, for condonation of delay.
Setting aside of abatement.
Setting as, my lord, condonation of delay at that
Those
point of time.
applications have also been dismissed.
Those have been dismissed, my lord, and in terms of that, my lord, restoration has been, my lord, filed subsequently, my lord.
What restitution?
Yes, Mr. Dev.
Allowed.
Where are the applications?
My lord, can 3 is the restoration, my lord. 2, my lord, is the substitution, can 2, and my lord, can 1, my lord, is for the condonation, my lord, of the delay in preferring the substitution application.
You have asked for expunging the name.
My lord, no, my lord. Substitution, my lord, I've indicated. I just. My lord, paragraph number 2, my lord, of can 2. The sole petitioner died, my lord, and in his place, my lord, the sons are to be, my lord, brought on record.
When did the sole petitioner die?
Annexed, my lord, if certified. My lord, it's on 21st of January 2023. So, my lord, there's a delay of 61 days in preferring the application can 2. And my lord, for that, my lord, I've preferred the condonation of delay application. My lord.
Can 3. Okay. This is an application for restoration of the applications being can 1 of 2023 and can 2 of 2023, which were dismissed for default by an order passed on 22nd September 2023. Paragraph, good grounds being shown, comma, the application is allowed. Paragraph, can 1 of 2023 and can 2 of 2023 be restored to their original files and numbers. Paragraph, can 3 of 2023 is disposed of. Can 1 or 2 একসাথে নিন। এরপরে next heading, can 1 of 2023 and can 2 of 2023. The applicants have prayed for condonation of delay in filing the car mobile. In filing the substitution application upon death of the sole writ petitioner. Paragraph, sufficient grounds being made out, the delay is condoned. Paragraph, the applicants be substituted in place of the sole writ petitioner. Paragraph, the cause title of the writ petition be amended accordingly. Can 1 or 2 are disposed of. Accordingly, disposed of. WPA তে order করুন. I'll fix a date for hearing.
The 62 Act, he filed an application, that application will be considered by the
Private respondents should be there.
My lord, I have served, my lord. Served all the they have received also.
My lord, your lordship will, SDO will consider his application. Application to বলে দেয় কত কপি?
My lordship, page 33, there is.
My lord, at page.
WPA তে order করুন, affidavit of service. None appears for the private তার আগে একটা লাইন করুন, by consent of the parties. The writ petition is treated as on days list and taken up for consideration. তারপরে by consent of the parties. তারপরে affidavit of service, none appears for the private respondent despite service. Where is the application?
My lord, it starts at page 33, my lord.
Page
starts at page 33, my lord.
The petitioners claim to be the recorded owners of the claim to be the successors in interest of the recorded owner of the plot in question and complain that the private respondent has raised unauthorized construction by encroaching upon government land.
I am for the private I am for the private.
You are for the private
Private.
respondent, yes. When none appears to give it, khali affidavit service. Yes.
Consider, yes. Consider by.
Yes, yes. You will be heard.
After
before the
hearing,
private body.
yes.
Have raised unauthorized construction by encroaching upon a portion of government land adjoining their property, comma, thereby obstructing their egress and ingress. Stop. The
Respondent number 3, my lord, SDO.
Yes.
SDO, my lord. The subdivisional officer, my lord, is the appropriate authority.
the original writ petition.
My lord, may I pray only one thing?
Submit.
I am not encroaching, my lord. This is my submission.
I'll
Yes.
record.
My record.
The original writ petitioner submitted an application in this regard before the concerned authority on the date of your application,
My lord, it's on 4th of July.
4th July 2022, which is yet to be considered.
It reached my lord on 6th of July. My lord, I sent it by speed.
Stop. The petitioners, I have recorded the date of your application.
My lord.
Stop. The petitioners pray for a direction upon the authority to consider the application. Consider the representation application at the earliest. Paragraph. Learned counsel for the private respondent submits that the private respondent has not encroached upon any portion of government land. Paragraph. Learned counsel for the state respondents submits that the
Respondent number 3, my.
3.
Yes, ma'am.
Third respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representation dated such and such within 3 months from the date of
After hearing the private
communication.
response. Yes, ma'am. Yes, ma'am.
From the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondent.
Or representative, my lord. Or his representative.
Private respondent / his authorized representative.
Yes, ma'am. Deeply applauded.
Disposed of.
Grateful.
Next.
Item number 9.
Now, my lord, yesterday, your lordship has seen, after perusing two affidavit of compliances, my lord, there was an inclination that your lordship wants to dispose of the contempt application. The learned advocate on behalf of the petitioner prayed an adjournment because of his learned senior. My lord, let him submit why this is, my lord, this should be kept pending, my lord.
Affidavit of compliance.
My lord, yesterday, my lord, I have filed two affidavit of compliances, one on 11th of August and also yesterday, my lord.
Take the last.
Yes.
It is premature compliance report, my lord, or your lordship may say it is half compliance report from their own aberrament as well as the law.
Why?
Because
Why do you call
your
it
lordship
half
kindly come to their paragraph, my lord, paragraph 9. Your lordship will get it. It still remains. They only referred it before the SDO, the magistrate, my lord. Magistrate already issued a notice. I have not yet received it. They have annexed here.
What was your
Ultimately,
representation about?
yes,
Your representation was about the unauthorized construction.
My lord.
unauthorized construction.
Upon disposing of your representation, notice under section 10 has been issued.
No, in accordance with law, your lordship said. So
Yes.
therefore, the entire liability on their part is, my lord, to get it evicted.
Substantially complied with.
Suffered the because your lordship kindly come to paragraph 9, your lordship will get it. that the deponent of the instant affidavit states that it is incumbent upon the statutory authority to issue eviction order after appreciation of evidence under the relevant statute. The deponent herein is under obligation to take consequential steps in accordance with law only after such eviction order is passed.
This is the
28
earlier, this is
yes.
the earlier report.
No,
Yesterday, another report.
no,
has
no,
been
it is
filed.
the present report. It is the present report.
No, you are reading the 11th
Paragraph
August
9.
No, no, my
Paragraph-
lord. He is reading correctly. Paragraph 9. I have stated
Paragraph
so.
9, they have stated.
So,
Yes.
Yes, my lord. He is.
Therefore,
There
this,
is.
this eviction notice, eviction order is to be passed by the authority. That is the magistrate. And after that,
Yes.
my lord, it will come back to their authority and they have to comply with the same.
My lord, there is no denial. In the event, my lord, what I have argued, there has to be a compliance of 10.3, then 10.4. Now, my lord, subsequently the SDO will pass order. The other side, they have a remedy before the district magistrate. Yes, my lord.
Your
My
state
lord.
authorities,
My lord.
they are-
He is
they have to,
interpreting is otherwise.
Well, 28th is the date.
It has been substantially.
My lord.
complied
My
with.
lord.
No,
If you lost it, because
Sir,
here our role is, well, very much limited. So,
this is substantially complied.
but your lordship kindly keep it open so that, my lord, we have to, my lord, because ultimately I have to go to another litigation. So just keep it open, my lord.
You have 10.4 is there for the.
My lord. My lord.
Yes.
record
Heard learned counsels for the parties.
And my lord, another thing, your lordship kindly take note of, my lord. এখানে জজের নামটাই আছে এটা একটু করতে বলো এ করে দিতে।
Oh,
Just
my
a
lord.
comment.
My lord. My lord. My lord. My lord, there is a mistake. Yes, my lord.
It is a
I do
mistake, my lord.
admit.
Page 32, my lord. The name of the concerned court, my lord, it is wrongly, my lord. Maybe
My
it
lord,
is,
WPA number is right,
It
but
may be taken note
my
of.
lord, it's an inadvertent mistake. I tender apology on behalf of my client. The name of the honorable judge, my lord, that is wrongly printed. My lord, I tender apology on behalf of my client.
Till now, I have not received. এটা বলেই তো হবে। নোটিশটা আমরা এখনো
It appears that the order under contempt has been.
and this,
substantially-
আচ্ছা, এটা তো
another this notice I have not yet received, my lord. This notice kindly note it, my lord.
Which notice?
Page 32.
Are you the encroacher?
No. My name is. I was also given. So therefore, according to them, my lord, I was also given a served a notice. So I have not yet received it.
You will receive only a 10.3 notice because you'll be heard.
No, but
Then
this one
is
was.
only about encroachers. Please see the law.
এটা কেন এ করবে? এটা তোকে দেবে না?
It is,
Yes,
pursuant to your
My lord,
consent.
my lord.
It is being done, isn't it?
My lord.
So 10.3, you'll be given an opportunity.
My lord.
Substantially complied with in view of
No,
the
I
above, the contempt application being
আমাদের
CP and
দেশে
sentence
তো
is
ওকে
disposed
দিচ্ছে।
of. Paragraph,
Objection
there shall
to-
however be no rest to cause urgency to by sector.
My lord, great.
Next.
Item number 10. Contempt application.
Lord, pursuant to your lordship's last order, my lord, we have filed an affidavit of compliance and we have served an advance copy to my learned senior.
Yes.
May I file that report, my lord? My lordship, the affidavit.
Yesterday evening, it has been served upon me, my lord. I have to contact with
My
my
lord,
Today?
yesterday only,
yesterday evening. at
during
5:30,
court hours.
And I have to, when they have annexed some photographs.
My lord, may I indicate, my lord, your,
Say that the order has been complied with.
my lord, your lordship on 12th of May directed the concerned officer in charge, the alleged contemner herein, to put the petitioner, who is a society having a lease to catch fishes in the river Ganges, in possession of the leasehold area. In compliance of your lordship's order, my lord, we have written to the BLRO and SDO on 22nd and 28th of September. My lord, we have annexed those documents. I am not taking your lordships on that. My lord, thereafter, we have written a letter to the petitioner on 28th of September, and on 29th, a demarcation was done. Petitioner was put in possession, and thereafter, my lord, we are maintaining a strict vigil in their leasehold area. My lord, thereafter, on 1st of October, petitioner raised certain complaints against few private individuals against before us. My lord, we lodged an FIR then and there, and we are conducting our investigation. The private individuals have also lodged a complaint. We have made an FIR to that aspect as well. My lord, we have pleaded in this affidavit that with respect to the leasehold area, my lord, we have put them on possession, and we are maintaining a strict vigil so that nobody disturbs their leasehold right of fishing. Whatever, my lord, is being complained, whatever has been complained on 1st of October, my lord, in our prima facie investigation has revealed that those persons against whom petitioner has grievances, they are catching fishes beyond the leasehold area of the petitioner. My lord, we are yet to file our final report, and we'll file a final report after having a conclusive year.
Lordship, here I would like to just intervene, Lordship.
You are appearing for whom?
Lordship, I am for the poor or fisherman, Lordship.
Are you
Here,
a party to the writ
No,
petition or the contempt application?
Lordship,
I'm
the
sorry,
fact
you are no
is,
locus, sir. I'm sorry.
no,
You
no,
can come
One
to the
more
court
thing,
and
my lord,
give
with
evidence
regard
law.
to the,
no,
Yes.
fact is,
my lord, one
Lordship,
more thing before
Sorry,
my
you
learned
are
senior
not
starts.
matter, sir.
My lord, one more thing before my
I
learned
have
senior
filed a
starts.
similar writ
Please
is
take
been
your seat,
pending.
sir.
My
It will be
lord,
considered
a
when it
subsequent
comes.
writ petition has been filed by the petitioner on the same issue, my lord, that is pending adjudication. My lord, that was my duty to indicate. My lord, that is
Yes.
WPA 26173
Do you want to go
with
through
regard to the
complaint?
subsequent complaints.
Complaint has been made.
Probably, my lord, not, because, my lord, there is some checkered history. In 2018, there is 2 High Court's order. Thereafter, my lord, perusing that High Court's order, your lordships passed this order, specifically directed to give protection regarding the catching the fish. What they have done, I have, my lord, in my application supplementary affidavit, I have explained the letter which they have issued purposely, that in respect of that letter, they have not whispering. As regards some photographs, they are showing that they have given possession in presence of the revenue inspector. That to that extent, I have to take instruction because some signature of my client is there in the
The area has been demarcated admittedly.
demarcation was made when the lease was given. Now they have taken a plea that it has not been demarcated in 2023. That's why they have not given protection. So, according to the my lord documents, the demarcation made by the district land reform officer in 2018.
No, no.
But
On 4th July 2023, demarcation was made. That is your submission before the court.
Again, my lord, on 29th of September 2023 as well.
4th July, my lord, in their presence, we went there. My lord, if your lordships allow me to take instruction to that effect.
Please come.
Yes. Then it will be clear, my lord.
Do you want to use an exception to this?
Yes.
Report in the form of affidavit submitted on behalf of the alleged contemners is taken on record. Paragraph learned counsel for the applicant petitioner seeks to use an exception to the report. Paragraph, let the matter appear under the same heading on 15 January. Please serve an advance copy. Next matter.
Item number 11.
Well, I am for the petitioner. Well, on the last occasion, I had argued before your lordship that if in a trial, in a proceedings, if the initial order of remand by the learned magistrate is illegal, then all orders subsequent thereto fails.
Place a judgment.
Well, judgments were handed over by my junior to your lordship's court officer on that day. Record judgment.
This is 2020 volume 10 Supreme Court.
Yes.
The relevant paragraphs.
My lord, kindly sees the first head note itself.
Note is sometimes deceptive. Please
Yes.
read the relevant paragraph.
Yes, my lord.
What is the stage of the trial?
It is at the stage of argument. It is almost at the stage of conclusion. We have filed bail applications because the state was delaying the progress of trial. When the bail application was filed, the Honorable Justice Bakchi, the division bench presided over by Justice Bakchi, impressed upon the state to ensure that the trial happens on a day-to-day basis. So thereafter, by keeping the bail application pending, the Honorable Court has forced the state to, no arguments are not concluded. It is at the argument stage. Be that as it may, my lord, my only legal point, and I am not on the merit at all. I am covered by the judgment of this Honorable Court. Yes, Vivek Chaudhary judgment. तीनटे judgment ही rely करें.
Note of only the Supreme Court judgment of 2010.
Yes.
No. My lord, 3 judgments. First, lordship kindly takes up Joita Das.
Are these reported judgments?
No, these are not reported
Well, if
judgments.
they are not reported, well,
Please give a copy.
No, you did not.
You should have given this on the earlier
Well,
date itself.
the last day I mentioned all the citations, including the CRR numbers.
The judgment, you are supposed to hand over a copy. Yes, you are referring to CRM 3590.
CRR 3180. I believe the reason I did not hand over this judgment to my learned friend is because my learned friend was relying on this judgment.
CRR 3180.
3180.
Yes.
এটা আপনি রিলাই করছিলেন তো বলে ডিভিশন বেঞ্চের জাজমেন্ট
Yes, he has not
Okay,
started.
very well. My lord, kindly comes to page 7.
Yes.
The Honorable here, Bikramjit Singh is relied upon. The Honorable Supreme Court was called upon to decide whether the magistrate has jurisdiction to remand the accused and extend the period of detention in terms of proviso to section 43D(2) of the UAPA in the face of notification issued by the state of Punjab designating a special court such and such, and goes on to discuss Bikramjit Singh, which I'll come to later. Now, my lord, thereafter, my lord, comes to page 9. The issue of, absolutely on the top, the issue of to whether the learned magistrate has power to remand in spite of case involving UAPA. The division bench of this court in CRM division bench 3590 of 2022 dated 1st December held hereunder. In the light of the aforesaid decision, we hold as follows. Once offences under UAPA are added to a case, magistrate is denuded of his power to remand in terms of section 167 of the Code of Criminal Procedure as amended in UAPA beyond a period of 30 days. Thereafter, the accused must be produced before the special court constituted under section 11 or 22 of the NIA Act, as the case may be, for the purpose of remand as well as extension of the period of remand in terms of proviso to section 43D(2) of the UAPA. In the absence of special court constituted as aforesaid, Court of Sessions shall exercise all powers and jurisdictions of the special court in terms of 22(3) of the NIA Act, including the power to remand as well as the power to extend the period of remand in terms of 43D(2) of the Act. In view of the above discussion, the order dated 7th April 2022 passed by the learned Chief Judge and all subsequent orders passed by the learned Chief Metropolitan Magistrate are illegal and inoperative and liable to be quashed. Similar situation in this case also. For the reasons stated above, the instant revision is allowed, etc., etc. But in this case also, exactly similar situation.
Yes.
And my lord, now the division bench order, my lord, 3590, which the Honorable Single Judge has relied upon. My lord, 3590.
Yes.
My lord, page 9.
Yes.
In this regard, reference may be made to state of Tamil Nadu versus Krishnaswamy Naidu and another, where the apex court held the special judge under Criminal Law Amendment Act, who has the power to take cognizance and try offences, shall also have the power to remand the accused, including during investigation, and the expression magistrate under section 167 CRPC must be interpreted to include a special judge. In the light of the aforesaid discussion, we hold as follows. Once offence under UAPA are added to a case, magistrate is denuded of his power to remand in terms of section 167 of the CRPC as amended under UAPA beyond 30 days. Thereafter, the accused must be produced before the special court constituted under section 11 or 22 of the NIA Act for the purpose of remand as well as extension of the period of remand in terms of the proviso to section 43D of the 2 of the UAPA. In the absence of special court constituted as aforesaid, Court of Sessions shall exercise all powers and jurisdictions of the special court in terms of section 22(3) of the NIA Act, including the power of remand as well as the power to extend the period of remand in terms of 43D. This Roman 3 is applicable in our case because in the state of West Bengal, special court has not been notified till date. In view of the paragraph 27, in view of the aforesaid declaration of law, we are constrained to hold that magistrate did not have the power to remand the petitioner to custody beyond 30 days after the offense under UAPA were added. However, remand orders were passed pursuant to a direction of the Sessions Court in the strike law as an act of court should not prejudice a party. If the accused has been illegally remanded to custody due to an incorrect interpretation of law, such detention would not be deducted for the purpose of statutory bail. The moot and goes to statutory bail.
It is an irregularity, not an illegality. Is it?
No, my lord, subject to correction, my lord, here with regard to the order passed by the court by the single judge has been held to be an illegality. My lord, I have shown, my lord. Now the division bench holds for the purpose of counting the days with regard to statutory bail, it will be an irregularity. However, my lord, for the purpose of remand as held by the single judge of this honorable court, and this order has been challenged before Supreme Court has not granted a stay. So this order still, this judgment still rules the field.
The custody order was challenged before the learned single judge.
Yes. Yes.
It was not at the trial stage at that time.
No, it was at the trial stage. Trial stage chilo to. Yes, huh? Vivek Chaudhary order to?
No, I find that the custody order was challenged.
No, this was at the custody stage. But Lord, my lord, be that as it may, my lord, whatever stage it might be before pronouncement of judgment, if I bring to your lordship's judicial notice an illegality, then my lord, that illegality needs to be cured and all subsequent action thereto falls, my lord. My lord, kindly takes up my petition, my lord, page. What number page to? 110.
Yes,
page 110, my lord, of my petition.
Yes.
Yes, absolutely at the bottom, my lord. Seen the prayer of IO who prayed for adding sections 16, 18, 20, 38, 39 of the UAPA. Hard considered aforesaid prayer for addition is allowed by for the interest of investigation. My lord, thereafter, remanded order.
Yes.
My lord, thereafter, in spite of adding of these sections, the learned magistrate, the learned SEJM has issued the order for remand. Page, very difficult to. Page mark here, page mark to I'll. So, my lord, the order of remand after adding of UAPA is illegal and all orders subsequent thereto must fail. These are my humble submissions, my lord. And whether it is at any stage, whether it's at the fag end of the trial or at the stage of remand, be that as it may, if an order is illegal, my lord, all subsequent orders fail. These are my submissions. Grateful.
I would request Mr. Ahmed to make his submissions after the vacation.
My lord, in that case, my lord, I have a reasonable suspicion that after the vacation, the trial will be completed and judgment will be passed.
Come back in the first week.
My lord, kindly at least passes an order that.
Can that be done when the division bench has directed a day-to-day
At best, he can.
trial?
He is
My lord,
entitled to bail.
my lord,
The bail application is pending there.
My lord, the division bench has not directed a day-to-day trial.
That was your submission.
No, my lord, the division bench was supervising a day-to-day trial by, there is no direction. It is only, the matter is getting adjourned from day to day and the division bench is directing my learned friend to ensure that the trial, there is no such direction. So, my lord, I am not even if, let me for the sake of argument, accept what my learned friend is saying, because I do not have the orders of division bench right now. My lord, even if the division bench has directed day-to-day trial, I am not asking for a stay of the trial. I'm not asking for a stay of the trial.
Go through these judgments and come back on the next day.
My lord, kindly passes a direction, my lord, that the judgment shall not be passed until unless this matter is
done. You will have your opportunity before the trial court to make this submission also.
very well, my lord.
Isn't it?
Very well, my lord.
For learned counsel for the petitioners. Now paragraph, let the matter appear under the same heading for further consideration on 10 January.
My lord, kindly on the first week of January, my lord, kindly on the reopening day, my lord, because lordship understands the urgency of the
Come
matter.
8 January.
8 January. And my lord, also in the meantime, we will prepare a notes of argument. We'll serve it upon my learned friend.
Do you think it's necessary? If you feel it's necessary, you can.
My lord, grateful.
Item number.
Next matter.
Item number 12.
Your Lordship, I'm paying for 2 weeks accommodation after vacation, Your Lordship. Lordship, kindly.
I'm for the respondent, my lord. On the last week, we had filed the report and they were given 3 weeks time to file the exception.
Your Lordship, my senior is completely bed rest for his back pain, Your Lordship. That is why, Your Lordship.
Learned counsel for the petitioner seeks extension of time to use the exception to the report in the form of affidavit submitted on behalf of the respondents. Paragraph, let the matter appear under the same heading on 25th January.
Lordship.
That's it. You want it in February? There'll be some more time.
2 weeks, fine, Your Lordship.
31st January. That's great. 31st January. Next.
Item number 13.
My lord, I'm the petitioner, my lord. In this matter, report is filed the respondent authority, my lord. Leave is granted to file the rejoinder, my lord. Rejoinder is ready, but not affirm this. I refer lordship to extend the time to file this rejoinder, my lord. Lordship.
State is not appearing.
No, lordship.
Fair. Learned counsel for the petitioners seeks extension of time to use the exception as sought. Paragraph, let the matter appear under the same heading on 24th January.
Lordship. Grateful, lordship.
Please serve an advance copy.
Lordship. Grateful.
Next.
Item number 14.
My lord, I appear for the petitioner, my lord. I am submitting my exception, my lord. My lord, on the last occasion, state was directed to, my lord, file a report annexing all the documents referred to in their earlier, my lord, report. But that has not been, my lord, annexed in the present report also, my lord. So I have taken a exception to that report. No, my lord. There is no, my lord, the land involved in the acquisition proceeding, how my land was involved in the proceeding, how they have, my lord, transferred it to the record, my lord, till LR record, ROR, my lord. My name was recorded, my lord. My lord. Documents. Exception of the and need to accept.
You want to come back after vacation? Exception used by the petitioner to the report in the form of affidavit submitted on behalf of the fifth respondent, is taken on record. Paragraph, on prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 25th January.
Yes, sir. Deeply. 25th.
Item number 15.
Your Lordship, I'm being led by Mr. Syed Nurul Arifin for respondent number 3 to 6.
What about petitioner? Who is appearing for the petitioner? No one. None appears for the petitioner.
Your Lordship,
Yes.
on 15/9/2023, Your Lordship has directed to file a report in form of an affidavit.
The report?
Your Lordship.
It's fine. None appears for the petitioner. No accommodation is sought. Paragraph, report in the form of affidavit submitted on behalf of respondent numbers 3 to 5 is 3 and 5.
3 and 5. The report has been affirmed by 3 and 5. Your Lordship, we are appearing for 3 to 6 because 6 is an agent, Your Lordship. It is for the
3 to 6 is taken on record. Paragraph, let the matter appear under the same heading on 29th January.
Yes. We have also been sent. We have also
For the state.
we have also given the report to the Union of India, Your Lordship. Grateful to Your Lordship.
Item number 16.
No. 16 my lord, I am for the petition. Sir, এটা কত?
Yes, private respondent.
My lord, yes, served, my lord. Notice has been served, my lord.
এটা আছে সমুদ্র এটা আছে ষোলোতে আর কি শুনলেন না
My lord, this matter.
Private respondents.
My lord, Mr. Supratik Shamal, my lord, was appearing. My lord, I have served a notice upon him, my lord.
He was appearing for 17 only. There was a direction for service upon all the private respondents. Yes. Not served.
But I've missed.
অরবিন্দ সাহেব বাবা
এটা 16
There is no initial service also.
ও আচ্ছা
Supratik Shamal.
Since service upon all the private respondents is not complete, comma, let the matter stand over till 25th January.
My lord, from 14 to 16, my lord, also.
Where is the affidavit?
My lord.
Where is the affidavit? You have not.
Affidavit, my lord, I'll just.
17 is only on record,
My lord.
not the others. 25th will not wait. 25th January.
Item number 17.
না 25
Lord, I am for the petitioner.
Report.
My lord, what happened, my lord? The fact of the case is, my lord, I am the owner of the land. My lord, in the year 1990, my lord, one memorandum of understanding was executed with KMDA for taking some portion of my land. Thereafter, my lord, they did not turn up. Now, my lord, the Howrah Municipal Corporation showing that agreement, my lord, they are taking the land for construction of road. My lord, I pray before the KMDA whether the land was ultimately acquired or not. My lord, KMDA asked for some RS record of rights. I supplied them, but they are sitting tight over the matter. As they are sitting tight over the matter, we are not taking steps against the Howrah Municipal Corporation for illegal encroachment of my land. This is my writ petition.
The reports were called for from the KMDA as well as the state.
My lord, consideration will not serve any purpose, my lord, because
We have filed our report. If your lordship kindly takes up our report.
Yes.
Paragraph 6, lordship kindly. This is the position. লর্ডশিপ দেখছি
So nothing has been done actually.
So we wrote to the BL and LRO to provide us the information. Otherwise, the
my lord, on the
details
other hand, my
cannot
lord,
be.
on 3rd of
This is the
3rd of
this is
February
the position.
2023, my lord, we have supplied the every documents. My lord, I want to show one thing, my lord,
You've supplied the documents to the KMDA.
to the KMDA, my lord. This is my letter.
কোনটা কোথায়
3rd February, and this is of 24th March report.
Yes, my lord.
February, this is to March. Lastly,
My lord, my premises number is 19 Kedarnath Mukherjee Lane. If your lordship kindly turn to, my lord, page 33, your lordship will find my adjacent plot holder, 18 Kedarnath Mukherjee Lane. That land has been released from the KMDA, my lord. My lord, if the adjacent land has been released from the acquisition, my lord, my land is unnecessarily taken away by the KMDA, my lord. We are praying for release of the land, then we can approach the HMC for such illegal encroachment. This is my prayer, my lord. Until unless the KMD release my land, I cannot approach the Howrah Municipal Corporation for such illegality.
At present, Howrah Municipal Corporation has nothing to do.
The KMDA is the answering response.
Yes, my lord.
Our name.
KMDA, this can be cleared by the state. The confusion which has arisen, my lord, which we have stated in our report, is the state to make it clear. Because
Here consideration will not really help.
Yes, my lord.
The situation has to come before the court. The fact situation.
Whether the land was
Because there was an agreement between the KNDA and the petitioner.
petitioners.
That was not acted upon. Petitioner is continuing to possess. Suddenly the Howrah Municipal Corporation comes in and makes construction. No, whether the land has been acquired, that document is necessary.
that plot information is necessary. That is why we
But on the
we-
other hand, my lord,
we-
in the LR record,
we
of
need
it, my land has
information.
been appearing till date.
we wrote to the state authorities, lordship, I have annexed the letters.
Not help.
My lord, last occasion, then previous occasion, my lord.
Let's take the clarification first and then approach us.
Let the state files a report. That will make everything clear. What the state report file না করলে?
অনেকদিন থেকে হচ্ছে।
Learned counsel for the state respondents. Seeks further extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 24th January.
24th.
My lord, if your lordship directs them, my lord, state files a report, my lord, only on one point, whether the land was acquired or not.
সবই দেবে।
That will be better, my lord.
Comprehensive report come before.
Comprehensive.
চন্ডিত বলেছে যখন করে দেবে।
Next,
Grateful.
pension matters.
Grateful.
Mention matters.
I am appearing on behalf of the private respondents. Just I received the brief from my client. Your lordship, kindly take this order after reopening after vacations. Your lordship, kindly.
The matter is, who is appearing for the state?
Actually, he's challenging the. I'll take some instruction from my client. Main allegation against the private respondent.
You are appearing for the state. Please respond, sir. I'm asking so many.
Only my objection is this: kindly come to page 23, raise an objection making unauthorized construction by the private respondent. So that objection has not been disposed of by the concerned authority. That is only
Government land or PWD?
government land. That is the Unauthorized Occupant Act, Eviction West Bengal land of 62 Act. So now only, my lord, after giving an opportunity of hearing to the parties, if it is
Your
fine.
lordship, kindly take this matter reopening.
No further instruction is necessary, sir. Your
Actually,
presence
your
will be-
lordship, kindly see it. He's paying the tax before the panchayat.
Does that confirm?
He's not the unauthorized occupant.
I'll record your submission that he is not an unauthorized occupant.
Yes.
Does payment of tax confer title?
Otherwise, if a person is not authorized person,
I may choose to pay tax for the Victoria Memorial. That doesn't become my property.
actually it was taken in respect of house tax
tax
was
is
paid to
taken,
the
You are aware, sir,
panchayat.
when tax is taken, especially by the panchayat, do they verify title?
No.
You are at liberty to
If
pay
a
tax for
unauthorized
any property.
occupant, his name should not be muted as the owner of the property.
Where is the mutation?
Actually, I haven't your lordship, kindly take this matter reopening. I will
Not necessary, sir.
satisfy you to your lordship.
An opportunity of hearing before the
I'm totally
authority.
handicapped.
You can handle all the documents before the authority. I'll not go into merits. Let the representation be
It can,
considered.
after hearing the concerned party.
Absolutely, yes. The petitioner claims to be the recorded owner of the plot in question and submits that the private respondents have raised unauthorized construction by encroaching upon a portion of government land adjoining his plot, thereby obstructing his egress and ingress. The petitioner submitted a representation in this regard before the concerned authority on 30th November 2022, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the private respondents submits that the private respondents have been paying tax in respect of the construction raised by them in the plot in dispute and are not encroachers thereon. That is your submission. Paragraph. Learned counsel for the state respondents. Do you have anything to add, sir?
Yes.
Just put a number BLR.
Subdivision.
BLR
Sit, sit, where?
BLR.
BLR.
There is the SDO.
Mala, the SDO is the competent authority.
Three.
And Mala, the inspection probably has.
The third respondent be directed to consider the, he'll give a direction.
Respondent is the authorized person.
Under section 3 of.
Be directed to consider the representation in accordance with law.
Subdivision.
Paragraph. In view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order.
Conducting an inquiry.
That is the process.
That's
Without
the
inquiry,
process.
cannot be ascertained.
So Mala, this is the consequential step.
Starts with
Consequential.
Rebate is given to produce all the relevant records before the authority consults at the time of hearing.
Mala, the consequential.
That is in.
No, Mala, that part.
That is included.
Again,
You don't have to come again. You are aware that after representation, steps are taken.
No. They have started only inspection, but nothing has been initiated. Issue the notice against
They have started the demarcation.
DLR.
I'll record that.
No, Mother, I have come to know from my client that a notice.
Unauthorized encroachment. That is
Within 3 months from the date of communication of this order, upon affording
be
reasonable
decided in the
opportunity of
civil
hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law.
main
Disposed of
allegations
with
with unauthorized encroachment. That will be decided by civil court.
Civil court.
What about
Next.
আমাকে তাড়িয়ে দিয়েছে
Item number 520.
Well, a report, separate report was directed to file. No, by the state and by the railway.
I have not seen, madam. He filed an application before the authority. And my lord, what is the, my lord, if your lordship will come.
6-9.
My lord, if your lordship will come, page 151.
Page
151, my lord.
of the writ petition.
Yes, my lord.
Yes.
Now, my lord, if your lordship will come, prayer portion. In view of the above, my right title interest over the said plot of land, that is 153, my lord. 154, my lord. Under the above facts and circumstances, I would request you to complete the acquisition process in respect of my land in RS plot number ato, LR plot number ato, move out the weekly measuring ato, including payment of compensation in public in accordance with law, or if such land is not required, hand over the same to me, my lord.
Yes.
My lord, now my lord, your lordship will see. Now, my lord, 164.
Yes.
Now, my lord, 165. That is 64 start information. Land in respect of RS plot number ato 64 last paragraph. See, my lord, period of notice.
165.
164 last paragraph. See, my lord.
Yes.
Period for which corresponding to Mayapur ato number within Arambagh block measuring ato area is the subject matter of my case regarding completion of acquisition proceeding, including payment of compensation on behalf of the Eastern Railway in connection with the scheme, namely Tarokeshwar Vishnupur, Bojboj Ato railway line, and pursuant to which I made a representation before your authority dated Ato, and whereas your authority finally conducted the hearing of such representation, and also written order has been passed.
Supply of copy.
Yes, madam. Pursuant to the RTI application made by me, that is the Ato, you have replied the queries, but copy of the written order has not been passed, madam. That is, there was a written order was there, my lord, according to him, madam. If not, my lord, written order not, that was complete. That will be completed by the authority. And my lord, if
my case is
my lord, if there is any acquisition proceeding, my lord, then they will start a acquisition proceeding according to the provision of Law Railways Act, my lord, 20 of the Railways Act, my lord. That is my lord, shortcut the matter. Otherwise, my lord, I filed the affidavit in opposition. I report.
Not opposition. Please come back with the
Yes, my
reasoned
lord,
order.
I filed the report.
My lord,
I
my
filed
lord,
that exception.
may I place my case? My case stands on page 163.
Yes.
They have turned down my fare. And this is the reply of the RTI application.
Yes, has been turned down.
Turned down. Thereafter, query number 2, they have admitted the note acquisition was not met. Thereafter, they also admitted TPPG, Tarkeshwar, already in possession. So they are in possession without acquisition. It is admitted. Let them conclude the acquisition proceeding. But 15 years they are in possession.
Admittedly utilized without acquisition.
Yes, ma'am. Only for that reason
That's why separate reports, because the
Yes.
DA says that they have, the land was given to by
my lord,
you
if
to them.
representation considered, if my lord, railway must come, my lord. If
Representation
railway
is
said we
already
must,
considered.
we must give the money, we must pay the money. How it will be paid, my lord, that
But
will
joint
be
hearing.
detected.
Representation has already been
Yes.
considered and
That-
turned down.
Yes,
That is page
that should
163.
be set aside.
And we still do not know what order has been, the details of the order. That's why a report was, separate reports were called for. Are you ready with your report, Mr. Ghosh? Because reports were called for from both the authorities, I think.
The state government will pay the compensation. Railway will pay to the state government.
Yes.
And the directly, railway will not pay the compensation money to the railway. And from the petition itself, their representation has not yet been considered.
Their representation has been turned down. Please come to page 163.
Yes, that I have seen.
Yes.
That I have seen. That just now, which is my learned friend shown from his representation. That his prayer is to complete the acquisition procedure and to pay the compensation.
Yes.
If not yet been done. So, concerned authority is the first authority to consider this. So, let there be a direction to consider his representation and dispose of it.
His representation has been disposed of already. And it has been admitted by the authority that land has not been acquired.
RTI application has been disposed of.
What? Please see first query of the RTI application.
Minor that 163. Page 163 is reply to the RTI application.
In reply to the RTI application, the authority has stated that the application filed by the petitioner
Yes.
has been turned down.
Yes, ma'am.
This is the reply. The reply has not been dismissed.
Then my submission would be minor. If his representation is turned down, then they have to challenge that order.
I have challenged.
Order was not
I
passed.
have challenged.
Where is that order?
Prayer
That-
portion,
That order is not annexed.
not necessary. He has heard that it has been turned down.
So,
He has come to the writ court.
let there may be a direction upon the authority concerned to pass a reasoned order. And my lord,
Please
that will
come
be
back.
challenged,
Reasoned order has been passed already. I would request you, the authority, to come back with the reasoned order. That's why reports were called for.
This
And
is
the
my-
reasoned order says that there has been no acquisition and the land has been utilized.
Yes.
That is admitted by the authority, by
Malady
both the
land
authorities.
is utilized, Malady. If that is so, my lord, they will, my lord, complete the
But kindly see
acquisition
the
proceeding.
paragraph
No
number,
acquisition
last
proceeding
paragraph.
was initiated. How will they complete acquisition proceedings?
My lord, they will, if your lordship, my lord,
They have to
wish
initiate.
direct, my lord. Then, my lord, railway
I
authority will
want
come
this
to-
to come from the mouth of the state. That's why the report was called. Let the state offer to either start an acquisition proceeding under the 2013 Act
Yes.
or go in for direct purchase.
Yes.
My lord, that is the procedure of the, but railway will, my lord, proposal will be given by the railway. Only for that reason, my lord, it is difficult for. My lord, only for that reason, my lord, to consider the representation, to reconsider. My lord,
has
yes,
been
my lord,
considered.
that is turned out, my lord, but
Yes.
that may be reconsidered as because that should not be turned out as there is a, my lord, utilize the land. That
Mr.
is
You
railway
say should not be turned on, your officer has turned it down.
But that is, my lord, that should be reconsidered.
Please come back with the reasoned order first. That only, he has not been supplied with a reasoned order. The state can come back with a reasoned order. Please come back with your reports. In this case, it cannot be, a shortcut cannot be made here. We have to see the reports, the reasoned order, and then pass necessary order. If
My
you
lord,
admit that you have
railway
utilized the land,
report is very necessary as because, my lord, they are utilize the land, how they will
report has been called for from both the authorities separately. So I would request both the authorities to come back with a report on the next day.
My submission is particularly in this type of acquisition process. When a railway doesn't know who is the actual one. Railway is getting the land from, as you requiring for. Railway is getting the land from the state of West Bengal.
How can the railway get the land? I want to see these
Railway
documents.
get the land from the state of West
If there is no acquisition, how can the railway get the land?
Railway? Because, my lord, for the project, my lord, the authority asked to the state
My lord, I
government
must give
for
the
land,
report.
and the land, my lord, that has been handed over to the railway.
I would like to see those documents.
My lord, I must
The
give
land
the
is not acquired. How can land be handed over to the
So, my
railways?
lord, whether it was acquired or not, that is to be
That is
declared
admitted.
by the state government.
State government has admitted that the land has not been acquired.
So, my lord, there may be.
That's why I'm calling for separate reports. Please express your stance. What about
My lord, I must find everything.
Raja, last one, one petitioner is 93 years old and cancer patient. For short time.
learned counsels for the state respondents and the railway authorities seek extension of time to
আপনার চেম্বার আমাকে যে বসে থাকতে হবে
submit the reports in the form of affidavit as called for. It has been recorded in the order. If the land has been utilized without acquisition, requiring body should either propose direct purchase or send a proposal to the state authority for acquiring. This was your submission on the earlier date. Paragraph, let the matter appear under the same heading on 17th.
17 January.
Please come back with your reports. Next.
Raja, last chance, but kindly.
Last chance. Last chance.
On the earlier date, it was directed. This is the first extension.
Second time, report.
First extension. Reports were called on the last date.
Yes.
Next.
Item number 521.
For the petitioner. Madam, this is the second round of litigation. First, yes. My lord,
yes.
Madam, the petitioner purchased the land of 5 kathas by virtue of the registered deed of sale from the erstwhile owner, who is the recorded owner. Madam, thereafter, Madam, the petitioner has paying the rent in respect of the said land, and he made constructions over there, and he is staying over there with his families. Now, Madam, he made an application for mutation of the name in respect of the said portion of land. But Madam, in the mutation proceeding, Madam, he has come to learn that land was acquired in the year 1970-71 by the special land acquisition officer for implementation of a drainage system. So, my lord, he made a representations that since the land has not has been acquired, but it has not been implemented as yet. On the contrary, the position is in favor of the petitioner. So he made an representations for release of the land from requisitions filed in view of section 24(2) of the Right to Fair Compensation Act. That representation was not considered. Therefore, the petitioner approached before this Honorable High Court, and Lordship kindly comes to page 80 onwards of my petition. This is the order passed by your Lordship.
Yes.
Lordship kindly comes to page 81 of the my lord, in a page 2. My lord, the middle of the order It is submitted on behalf of the respondent that the Special Land Acquisition Officer South 24 Parganas be directed to consider the representations in accordance with law. Therefore, your lordship passed the order to conduct a hearing, giving opportunity of all the parties, and they conducted a hearing. Now, lordship kindly comes the order of the hearing. It is an order that is starting from page 87. Lordship kindly comes to page 89, which is the relevant part from the middle part of the page 89. They are saying that it has already been requisitioned in the year 1970 to the irrigation department. So land is not with them. So therefore, they are unable to take any steps. This is the sum and substance of the reasoned order. But my lord, it has already been requisitioned in the year 1970 or 71 that has not been disclosed by the on the part of the state during the course of the hearing in the earlier petition. So, my lord, the petitioner filed this application.
Earlier petition was only a direction for consideration of the
Considered. No, but that land has already been requisitioned. That has not been, my lord. There was no
subsequent purchaser.
And the subsequent purchaser. Now, my lord, I made another representations now to the requisitioning authority. That is page 91 onwards of my petition. With
These numbers are not tallying. You said 89, it's actually 91 here.
Lordship,
You're talking about the representation, it's 93.
My lord, sorry, my lord. Representations with almost same prayer for release of the land from the requisition petitioner is ready to pay back the whatever compensation he has. Although he has not got, the earlier owner has got, but he is ready to pay. That government is also there. But my lord, as per section 24(2) of the in view of section 24(2) of the Right to Fair Compensation Act, this is the prayer of the petitioner.
Are you aware that no compensation was paid to the predecessor, to the erstwhile owner?
My lord, in the recent order, they stated no, my lord. When I purchased the land, it was not disclosed to me, my lord. But in the recent order,
you are a subsequent purchaser, you cannot challenge the proceedings at all.
No, my lord.
No right.
I am not challenging the proceeding is over, requisition has been made. I am only with the prayer for release of requisition in view of section 24 of 2. I am not challenging the proceeding.
24(2) says either possession or compensation.
Yes, your.
Either of the two.
Either of them.
So you are not aware whether compensation has been paid. If compensation has been paid, 24(2) doesn't apply.
My lord, your lordship can see page 89 second paragraph. That is all. Order dated 24 July 2020. 89.
Pages are different here. It's 91 here. 24th July order. Yes.
89. Second paragraph.
Yes.
On verification of the office files and records, it transpired that the SUVRA depot pertaining to APO record was entirely acquired in land acquisition case number APO for the excavation of intersection of channel under Taligarh APO by notification number APO 1970 under section notification number APO dated 14th March 1975 under section 4(1)(a) of the West Bengal Land Acquisition Act. Subsequently, possession of the subject land was made over to the requiring body, Superintendent Engineer, Greater Calcutta, Dennis, in 6/5/1971. Possession of the West Bengal Land Acquisition Act was part of the square landowner as well as the transfer of the instant petitioner on 6/11/76 and one photograph all the received the same notice on behalf of the Mistari Midasi. It also appeared that award was declared on 2/3/81 by the collector in the name of the erstwhile recorded dayas, namely Mr. Midasi, Vedanath and RS record, and Moja amounting to rupees for entire land value of the
Yes, sir. The amount has also been received.
Yes, my lord. That I cannot deny. They received.
So what is your locus?
My locus is, my lord, since the possession, my possession is with me since the.
It's come to 24(2).
Yes, your lordship.
Either compensation to be paid or possession taken.
No, lordship. That is lordship. Yes, madam. Notwithstanding anything contained in subsection 1, the case of land acquisition proceeding initiated under the Land Acquisition Act 1894, where an award under section under section 11 has been made 5 years or more prior to the commencement of the act, but the physical possession of the land has not been taken or the compensation has not been paid. Here, the physical possession has not been
There's an
taken.
or. If either of the two is complied with, then 24(2) doesn't apply. There are a category of judgments on this.
My lord, yes, my lord, but lordship kindly see the judgments. My lord.
Yes, the relevant part.
My lord, here lordship kindly see here the physical possession has not been given, taken, although the compensation has been given. So, my lord, in that case, even my lord, the 24(2) is applicable, my lord.
Please see the statute itself, madam. This is a single bench judgment. There are latest recent judgments of the Supreme Court which clarify the issue. You are aware.
I'm aware, my lord.
You are aware of the Indo development
Yes,
judgment also.
I am aware of that.
You have placed a single
My
bench
lord, let
judgment.
the matter be sent to the authority concerned at least,
Question.
my lord, so that
For what?
my lord, do
24 doesn't
consider,
apply,
do
it will
consider
be
because
dismissed.
my lord, let the matter be sent to the concerned authority.
Why unnecessarily encumber the authority with a matter which doesn't really call for consideration at all?
No, my lord.
You are admittedly a subsequent purchaser. Compensation has admittedly been paid. So you have no case. I can at best ask you to withdraw. I have to dismiss the matter.
My
If
lord,
you need further instructions, you can.
lordship, can
There
you
is
keep
no
the
case
matter
at all.
after vacation? In that case, I will have to take instructions.
Let the matter live.
Because I know indoor development, my lord, I had a talk with my
Let,
client, my lord.
let the matter enjoy the Christmas and the New Year and then come back to die. There is no case, sir. Madam, I'm sorry.
Kindly keep it. I will, whether I will withdraw it or your lordship.
Please take necessary instructions.
Yes, your lordship.
Upon giving the relevant instructions to your client. Mr. Dey, let the matter live for the vacation.
Another half an hour will be lost for the court.
On the next day?
Yes, my lord.
No, I remember.
Typical job, my lord. When the petitioner has not any case, my lord, he knows the indoor development. Indoor development basically says that if 4-1 is there, after 4-1, then nobody has the right to say that I am in possession.
24(2) is not applicable in this case.
24 is not that is the relevant.
After vacation.
After
My lord, whatever will be that court's time, my lord.
Let
No,
the
basically,
petitioner see the new year and then let's go. I'll not record anything because that will go against you. On merits, I cannot say anything in your favor.
Gratefully,
Heard learned counsels for the parties. Paragraph on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 10th January.
lordship. 10th January. But can it be on 15th?
15th. Very well, 15th January. Next.
Item number 522.
Same, my lord, my affidavit of service, 2 deeds, therefore 2 matters, my lord.
Similar issues.
Similar, same.
Mr.
Same
Dey is appearing
parties.
in this matter. The second next. So on your prayer, let it be adjourned on the same day. On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 15th January.
Date.
Item number 523.
My lord, I am for the petitioner, my lord. The petitioners allege that they are the heirs and legal representatives of their predecessor father, who got a allotment in a respect of a plot of land in Kolani for 999 years. He has
Your father got the allotment.
Lordship. He has complied with all the terms and conditions. After making the payment of salamis, he has utilized the plot by raising construction of 2-story building. But the petitioners allege that during the lifetime of the father, he never called for by the respondent authority to execute the lease. On the Lordship, kindly, they have submitted their application because nowadays online application is only permissible. Lordship will find page 32 onwards, their application. upon payment of GPRS, GRIPS channel, the relationship certificate, Aadhaar cards, affidavit, page 32 starts. Next page
You
33.
have deposited the entire requisite.
Enter. Now, my lord, what happened? My father, Gokul Chandra Goswami, who got the allotment, who died in the year 2014. After his death, our mother was alive. We submitted an application, but during the pendency of the application, that first application, my mother died. So that application became infructuous. So after the death of the mother, now we are the only sons, 2 sons. There are no daughters, no private respondents are there. We have claimed this property by way of submitting our application for death mutation. Our only prayer is this: let the lease deed be executed in our favor, and the property be mutated. And my lord, on the same cause of action, similar issues have already been cropped up by our coordinate judge of this court. The similar issues wherein the lordships were pleased to direct them to execute the lease deed with the heirs and the legal representative.
No, it is a different case, madam.
It
It is not similar.
But the proposition is a similar, my lord. Apart
No,
from that,
proposition
Supreme
is
Court
not similar. I am
absolutely-
differ with you.
And my lord, I am coming, my lord. ধীরে ধীরে আসছি।
আমি
You received
ছিলাম।
a copy of the report?
তুমি যেটা দেখাচ্ছ সেটা
Yes, I have
আমি
received the copy. There is no allegations against me. Only one allegation is there, that one death mutation application during the lifetime of mother was submitted. They called for a hearing. We could not attend the hearing. And they have already submitted a report also that the plot has been well utilized by the parties. There is a construction. They have given an inspection report. If you will also kindly turn their report. Well, they have given the death certificates of. If you will also kindly take page. Well, inner page. This is the inspection report. It is annexure. Most probably page 15.
Have you filed an application? Because they have not turned down your.
No, I have filed the application through online. Submitted by
that is
application.
pending. That is pending.
That is the pending.
Let
My
that be considered within a
only
limited
thing,
period.
in view of the judgment passed by this.
No,
court,
that should not be.
apart from this,
That should not be.
apart from this, Apex Court is there. Apex Court, I am coming with.
I'm not with that.
Apex Court.
I'm opposing this application. No.
Apex Court decision to the.
Let them
দিলেও হবে না. It should not be.
independently.
Yes, madam.
Why encumber them with all decisions, earlier decisions?
Lordship
Fact
giving.
situation may be different, and the moment fact situation is different, if they
Well,
find
by-
within a
by-
line,
Yeah,
they
Lord-
reject your application. Let them take an
Their
independent
application is pending. Let it be decided by the
It is in
authority.
accordance with law.
Yes,
President statute,
yes.
and keeping in mind the plot has already been utilized. They have never called for execution.
Without execution of deed, how they
No,
can
you
raise
did
the
not call
construction?
for. You have
Understand, sir.
violated the agreement.
Let
You
the,
have violated the.
No, apart from no, absolutely not.
let the application be decided
Madam.
independently. The moment you place earlier judgments, the authority is an expert in finding out 1 or 2 differences and turning it down on that ground.
Madam.
That
But
will not be a
Only
very
one
happy
for my
situation.
satisfaction. Supreme Court judgment is also there. If this is a long-term lease.
Then you will have to go before the civil court. Lease
Why
agreement
civil
cannot
court?
be.
Why civil court?
Lease agreement cannot
Why
be
civil
challenged before the writ court.
He's not challenging.
I'm not challenging the read lease agreement. Madam, kindly see paragraph 8.
It is not applicable in this case, my lord.
আরে আপনি না পড়ে কি করে বলে দিচ্ছেন সবকিছু?
Paragraph
1997 2 Supreme Court case, page 387.
দেবাশিস বড় সাইটিংটা বলো 1997
2 Supreme Court case, page
সুপ্রিম
387.
387 তুমি একটা কপি থাকলে দাও না
দিয়ে দেবো।
একটা কপি থাকলে দাও
Lord, here the governor.
This is a different issue altogether.
Well, I'm showing
Right
only
of a
this
lesser
what
to transfer.
999 years lease.
In favor, yes. So that one line doesn't make it same.
But we are the predecessor. My predecessor interest got the allotment. He
I'm not
complied
disputing
with-
that.
Okay, Lordship, then it is recorded.
I'm not disputing.
Let my learned friends submission
That is
recorded.
exactly, they have not disputed anything.
Lordship, then
They have only said in the report that it is pending, that's all.
Yes, ma'am, that is pending. Let it be decided.
highly decided.
Let it be decided.
Directed
Considered upon execution of the lease, that is the report.
Lordship,
So why do you want to place this? This judgment is not at all the pat on the point.
Lordship.
The question is whether the lessee has a right to transfer in favor of strangers. Is that the case here? No.
No, but the legal
They
heirs,
picked up that
but the
sentence,
heirs
99
and the legal
99 years.
representative of the original lessee has got the right.
That is not in dispute.
Lordship. Then okay, Lordship.
That is not in dispute in terms of the lease also. Where is your application?
My lord,
But they have earlier made representation. They have called for the hearing. They have
mother died. Mother died.
thereafter mother died in the 2020-21. Their earlier application in the 2014 and 2015.
Now that application became infructuous due to the
But the
death of
last
the mother.
Last application is pending.
Where is it?
2021.
No, last application
Page 35.
15th May 2023. This is the offline application.
Yes.
And prior to that, online application dated
Where are
5th
these
of
applications?
Lordship, 5th of February 2023. Acknowledgement. Lordship, kindly see application date, page 33.
Page 33, 35.
33, 34 payment, acknowledgement date, 5th of February 2023.
This is for mutation.
Yes, I'm
Debt
praying
mutation.
for, only
He's
debt
praying
mutation.
for mutation.
I'm praying for mutation. And another last application, my lord. Lordship, kindly see the
But the deed needs to be executed first, isn't it?
No, my lord.
first mutation is required.
Mutation is required. Debt
Thereafter
mutation. It
No,
was,
no,
my lord, it was allotted in favor of one Gokul Chandra, father of the petitioners. Possession handed over.
And there is no
But-
deed till date.
Thereafter, one after another, my lord, the petitioner's father and mother died.
Yes.
Then now again, my lord, they have applied for mutation. That is pending.
And last application, Lordship will find at page 49.
49.
Lordship. 15th of May 2023. Oh, okay.
It's
15th May.
May.
Prayer for lease deed.
Yes.
Did you file a comprehensive representation? It's not very happily drafted. Please read the representation.
But everything has been submitted through online, my lord. Let that online application be considered.
Where is the online application?
Page 33. This is their acknowledgement.
This is the acknowledgement.
Yes, that is online.
On 5th,
Online, actually, they have given some certain pro forma, has to be filled up.
So let that be considered.
Lordship.
Report in the form of affidavit submitted on behalf of the second respondent is taken on record. Paragraph. The petitioners are the legal heirs of the original lessee Gokul Chandra Goswami, comma, since deceased, comma, who was allotted the plot in question in Kollani Township by virtue of an agreement for lease for 999 years, 999 years, executed on 31st August 1963. Stop. Upon demise of the original lessee and thereafter his wife, comma, the petitioners have stepped into the shoes of their predecessor in interest. The petitioners applied for mutation of the property in their names as well as execution of deed of lease in their favor on 5th February 2023, which is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the application at the earliest. Paragraph. Learned counsel for the respondents submits that an inspection of the premises reveals that a two-storied building has been constructed therein paragraph, it is not in dispute that the application submitted by the petitioners is pending consideration by the authority and no lease deed has been executed in favor of the original lessee or the petitioners, though the land was allotted to the original lessee on 31st August 1963. Paragraph, in view of the above, comma, this court is inclined to hold that since the online application made by the petitioners on 5th February 2023 is admittedly pending consideration by the authority, comma, the concerned authority, comma, being the
Respondent number 2.
respondent number
2.
being the second respondent herein, comma, be directed to consider and dispose of the application within 2 months. Within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioners, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof. Disposed of, exactly.
But may I take back that Supreme Court judgment?
This.
No, Supreme Court judgment. Supreme Court judgment. Grateful relapse.
Next.
Item number 524.
Similar or
Yes.
this is stage also.
But I'm filing the evidence service. Land of the petition. Land of the petitioner requisition under Act 2 of 1948, subsequently not acquired. In the meantime, scheme has been abandoned. In that case, I am entitled to get release of land and requisition compensation damages. And this is covered by your lordship's order at page 31. Under the same scheme.
You have filed a representation?
Yes. At page 35. Date of representation.
জমা দিয়েছে কিসে? জমা দিয়েছে কোথায়?
17th July.
By post.
Yes, 17th July.
By post.
Yes, Mr. Bandhavata.
Let it be
Let me
combined
see about it.
according to your lordship.
Affidavit of service filed by the petitioner is taken on record. Paragraph, it is contended on behalf of the petitioners that their land was requisitioned in terms of the West Bengal Land within bracket requisition and acquisition bracket closed Act 1948. But the land was not acquired subsequently. Stop. In the meantime, the Act of 1948 stood repealed with effect from March 31, 1997.
And the scheme also
Uh,
abandoned. Kindly mention this.
The scheme was also abandoned. Paragraph, the petitioner submitted a representation before the concerned authority
Respondent number 3.
on 17 July 2023,
Yes.
seeking release of their petitioners, release of their land and payment of compensation. Stop, the representation is yet to be considered. Stop, the petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the respondents submits that the third respondent.
Third.
Third
It will be
respondent.
better fourth respondent.
Special land acquisition officer.
Yes, yes.
Special land. The fourth respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the fourth respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 2 months.
Here, it was 3 months. 3 months.
So 3 months. Everything has a disadvantage also. Within
I
3
told
months.
by the department, Mr. Hajra is going there with lot of bunch of this.
There are several matters, same issues.
He is specialist of Mundeswari.
Within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Paragraph, in the event the representation is decided in favor of the petitioners, all concerned, including the petitioners. In the event the representation is decided in favor of the petitioners, necessary consequential steps be taken by the fourth respondent within a month thereafter. Disposed of, which actually. 3 months, 4 months. That is also in the earlier order. That is also in the earlier order.
My lord, item number 556. Same issue, my lord, Mr. Bandyopadhyay is appearing.
Sitting এখন কি করে হবে?
My lord, I'm giving 556. Already list. Already list, my
I
lord.
cannot jump, I'll call.
Similar, Mr. Bandyopadhyay, I have to wait for Mr. Bandyopadhyay.
I have to find out the file. 556, same order record.
556.
Representation date?
Yes.
Pavan.
আমাদের brief নেই জানো।
4th of September 23rd. 4th of September. I'm filing the evidence service.
556 করে দাও তো আমি যাই না। বলছি আমি দেখিনি। 556 ওটা তো লেখাই নেই।
Wait, wait.
No. 525, 6, these are all similar matters?
Yes, 556.
No, after this also I find your name.
Not similar, but
What? All Mundeswari. All Mundeswari.
556, 27235.
I'm filing the evidence service.
ওই ওটা কে আছে আমি কি জানি না। দেখে নি।
Page 37 is the date of representation.
ব্রিফই নেই তো আমি করবো।
Page 35.
30 starts. Date of page 37.
জুনিয়র কে আছে?
4th September 2023, representation date. A petitioner's yes. Our fourth respondent. Disposed of.
ভালো।
Next. Service these. Next one.
Next is similar. Mr. Dey is appearing.
Number 525.
Yes. But date of review 21st August. Yes.
I'll call one.
Can you see my page 35?
Representation 21st August 2023. This one into that. Affidavit of service. Same one. Next. Next matter.
Five 26.
I am for the petition. And what happened in this case, my lord? Land of the petitioners were requisitioned.
Yes.
No acquisition was made. In the meantime, road constructed. Under the same scheme, 6 writ petitions were filed by 6 other landowners, where honorable single judge directed to complete the acquisition proceeding as per 2013 Act and pay the compensation. Challenging that order, states filed appeal. Appeal fails, thereby upholding the order of the single bench. Kindly see. So, the issue has been decided by the division bench. Kindly see page 56 first, single bench order. May I read, Madam? The petitioner, page 56, Madam.
Yes.
The petitioner claims that 30 decibels of appertaining to Pranav Mauja under police station in the district of Hubli was requisitioned under the provision of Act 2 1948. The rent compensation was paid to the petitioner for said requisition. However, land was released from the requisition by the state of issuance of any specific order. Was not. On the contrary, the state had constructed the road on the land of the petitioners without initiating any acquisition proceeding and without making any payment of compensation. The report submitted by the BLRO kept with compliance with the direction given by this court on September 30, 2015 is kept on record. It appears from this report that the road has already been constructed on the land measuring so and so, my lord. And admittedly, no land acquisition proceeding is initiated against the petitioners for encroaching the land of the petitioner for the purpose of construction of road. The further admitted position is that the petitioners have not paid any amount of compensation for construction of the road on the land of the petitioner. Accordingly, the respondent number 3, land acquisition collector, is directed to initiate the land acquisition proceeding against the petitioners under the provision of rent to, sorry, that will be right. Rent, fair compensation and transparency in land acquisition, rehabilitation, and to both pay compensation according to construction in certain period. It's 57, 56 to 7. No. Appeal file. No.
Yes, Mr. Dev.
That I must carry out the order of the order.
And thereafter, the appeal, kindly see the appeal court order.
I've seen the appeal order.
Yes, but this issue has been in the similar scheme.
Compliance, I have direct purchase. That is very, because there is very rule ballot, by ballot, then I can do for direct purchase of Zilka commission of.
But so far, appeal court judgment is.
My otherwise, according to the component of the right to bear act, that was complete the procedure. Must complete the procedure.
That will be the actual compliance of the law.
Must complete the procedure.
Affidavit of service. It is contended on behalf of the petitioners that their land was requisitioned for the purpose of construction of Bonomalipur-Fatehpur VR to Gotan Road, GOTAN Road, under Section 3 within bracket 1 of the West Bengal Land within bracket Requisition and Acquisition bracket close Act 1948. V-Day requisition case number I, capital I, hyphen 40 / 1975 hyphen 76, and possession of the land was taken over by the third respondent in 1982 and handed over to the fifth respondent, comma, being the requiring body. Stop. No acquisition proceeding was initiated, comma, far less any compensation paid to the petitioners for their land. The land has been utilized by the requiring body by construction of the road therein. The petitioners have prayed for a direction upon the concerned authority to complete the acquisition proceeding in terms of the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act, 2013, and pay compensation to the petitioners accordingly. Stop. A similar issue, the issue raised in the writ petition has been set at rest by a judgment passed by a coordinate bench of this court on 19th June 2017 in WP number 24940 within bracket 24940 within bracket W.
The appeal, my lord, is he is not filing appeal against the, we are not filing appeal against the order of the appeal lordship of the order of the previous honorable judge, my lord. That is, he showed another order.
Yeah, I have said so. Similar.
No,
Sir,
my lord, that is not the.
I have
My
said
lord,
that issue has been decided.
That I have, my lord, I have the report, my lord, instruction, my lord, if your lordship will see, that is not in the
All
report, my
these
lord.
appeals are similar, but is this also included in the appeal?
No, my lord. I have said similar writ petition was disposed of.
If your lordship will see my report.
But I have not filed earlier writ petition. This is admitted. I am relying upon the judgment of the Honorable Division Bench.
My lord, then my lord.
Being similarly circumstanced.
My lord, I filed my lord instruction now.
Being similarly circumstanced.
No, my lord, that is. I understood what that.
If I file earlier writ petition, why this writ petition?
Then, my lord, I must take I give the instruction, my lord, as per. Not similar, my lord, as the.
Where is the order against which this appeal has been preferred?
Yes. Page 57. 56 starts from page
This is
56.
Basudev Sarkar.
Yes.
And Nikhil Sarkar.
I have said of 6 analogous writ petition were filed. Writ petition were filed under similar circumstance. This court decided the issue. I have said.
Yes, so the appeal should cover this judgment also. Where is that recorded? Ashit Dash and others.
He is not the.
I am not that writ petitioner, my lord. I have said so, my lord.
Similar matters, but
Yes.
the appeal should be
Yes,
accompanied by the single bench judgment. Where is that?
Yes, 56, starts from 56. Ashit Das.
Ashit Dash was not appealed again.
Yes, yes. Page 59, my lord. Kindly, my state, first matter, state versus, state of West Bengal versus Ashit Das.
Yes, Mr. D, it's there. Ashit Das and others. This judgment, several judgments have been taken up together in the appeal.
Analogously, 6 matters
Yes,
were heard,
yes.
yes. 59.
The first matter.
Ashit Das.
কি বললেন? Within bracket W.
My lord, I was
2015.
my lord,
It's recorded, Mr. They know you.
as because my lord.
Please come to page 59. The first matter is State of West Bengal versus Ashit Das and others. Please point it out to me, Mr. Hajra, please.
Yes, my lord, I have.
ওইটা রিট পিটিশন অসিত দাস রিট করেছিল, স্টেট অ্যাপিল করেছিল।
হ্যাঁ করেছিল।
It is an appeal against this writ petition.
Yes, my lord, that. Then my lord, your lordship.
Line sentence to put on the matter has been set at rest. By stop in the said matter, comma.
Similar matter, similar matter.
The state constructed a road on the land of the petitioners therein without initiating any acquisition proceeding or paying any compensation for the same.
Right.
Yes.
In this matter, my lord, Beat Singh of Kumar Rai.
Ashit Das and others.
My lord, in this matter, Beat Singh of Kumar Rai.
First name is Ashit Das.
No, I am not on that point, my lord. But is a new case, my lord. Facts of the same is not similar to that. That is the, my lord, previously, my lord, that is the order that is passed, my lord, in 56. That is the WP number 24940 of 2015 Ashit Das.
Yes.
Now, my lord, the petitioner has come in Beat Singh Kumar Rai in WP number 23,471 of 2023.
Where is
New
this
case, my lord.
New case, similar case. I
Yes,
say.
similar
Whether
issue.
similar or not, my lord, that will be considered.
Issue, the judgment says so.
No,
Let me
my
pass an order, Mr. Dey.
My lord, your lordship will only hear me, my lord. This is not Ashit Das. This is Beat Singh Kumar.
I know that. Ashit Das has already been disposed of.
How will be, it is Ashit Das, my lord.
Circumstance.
Yes.
That's, my lord, similar means, my lord, whether the facts of the case is similar or not. My lord,
Go through the judgment. Fact is
my
similar.
lord, if your lordship will give the brief history of in connection with this. I have handed over the brief history of this case, my lord. Present case.
The judgment is more.
No, my lord. That is another fact of the case is different from that.
Fact is same, Mr. Dey.
My lord, if your lordship will see my another person came before your lordship and said that similar facts is there. My lord, I must see the whether similar facts or not. According to my instruction, my lord, this is not a similar fact.
What is your instruction? I cannot
My lord,
make out anything from this instruction.
My lord, in the first place, it is brought to the notice to the Honorable Court that the petitioner, wishing or 10 others, filed a prayer dated Atho, identical ground in the office of the undersigned on Atho. They did not submit any relevant document in support of that claim, along with their prayer. The office on receipt of the same after completion of some official formalities started working on it and searching of the original old land acquisition case records and document related to it, with intention to provide relief to the petitioner as sought for their prayer. After that initial work, the notice of hearing for consideration and disposal of their prayer was issued, fixing the date of hearing at all. A detailed examination of the claim of the petitioner along with the field inquiry may also be required for disposal of this prayer, but without keeping reliance upon the action to be taken from the government authority in respect of their prayer, and without providing any opportunity of consideration of their prayer, they rushed to the Honorable High Court and have filed this instant writ petition also, almost on the date of completion of 1 month of the submission of the prayer of this office. The act of the writ petitioner clearly indicates that they submitted their prayers in this office just to maintain the formality prior to proceed to the High Court with the plea mentioned herein, and that no action has been taken from the office in respect of their prayer. It is quite unbecoming in the eye of law that the petitioner submitted their prayer to the concerned government authority for not seeking actual relief of their grievances, but to make way to proceed the High Court within a month time, citing that no relief has been provided to them for the government authority. This is important to mention here that the first day of hearing has been completed on Ato, and the next hearing date was fixed on 7/12/2013. In view of the above, the instant writ petition submitted by the petitioner may be kindly be rejected to provide the office opportunity to deal with their prayer on 24th in order to consider and dispose of the prayer.
That is your submission?
Yes, ma'am.
I'll record this and I'll dispose of the matter. There is nothing stated in this. They are
Well,
angry
he filed
because
an
the petitioner did
application.
not wait for their
He
decision.
filed an application. We have considered that, my lord, that thing, and now he comes and got the order. The similar situation is there. My lord, he is not coming with clean hands.
Clean hands. What
Yes,
is
my
the-
lord. That is, my lord, according to my brief history of this case, my lord, he has not come with the clean hands, my lord.
But they are
My lord,
keeping-
your lordship can pass the order, as because my lord, your lordship has the right to pass the order.
What is unclean? Please explain, Mr. Dey. I
My
do
lord,
not
you are unclean. He filed an application before the authority, and he has within 1 month, when my lord next date of hearing was there on 7/12 or 23, my lord, that petition, a copy of the petition of hearing, and he come to the court and honorable get showed that there is
The
a similar order.
respondent is showing unclean hands because after the writ petition was
Yes.
filed, the date was
Yes, grateful, madam.
It was filed, writ petition was filed in September. Then you fix as soon as the notice goes to you, you fix the next date in October.
For that reason, my lord, he will not get the benefit of another similar order. My lord, what similar order?
It is identical to this petition.
My lord,
That has happened in the
I
earlier
differ, my lord. I must file the affidavit in opposition, my lord.
Affidavit in opposition.
Yes, my lord. As because, my lord, this case was identical or not, I must show.
If you
your
want to see
lordship.
and come back, I can give you time.
Yes, my lord.
Let it be adjourned, let it see.
But
Come
two,
on. Because
they
it's
have
identical.
they have heard.
Yes, my lord.
But after the writ petition,
But
they
I can't understand. Beat Singho is not hurt by. I never file against the Beat Singhos. That is this writ petition, namely.
I'm relying.
Anyway, let us.
I am relying upon the.
No, my lord. That is.
Mr. Dey is not in a mood to concede today. Let him come.
Yes, my lord. I have always conceded, my lord, but when there is something, my lord, I can't want to.
There is nothing, Mr. Dey. Please
My lord,
come.
I must come
Please
with
consider this and
my lord, I must come with a report, my lord.
affidavit of service. Bucket of category. Learned counsel for the state respondents seeks to, you can take this back, and this is not even on affidavit. Seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading on 25th January. Next.
Next is similar. Next is similar.
Mr. The report in the next matter was.
But my line
You are
is
not
not
in the
appearing.
Who is appearing?
Item number 527.
I have sub notice, also upgradation notice I have sub. 28th.
So then may I request you to appear in this matter? Similar. None, where is your affidavit of service?
Yes.
Affidavit of service, none appears for the respondents despite service. Mr. Their appointment regularized school. Service direction. Paragraph, let the matter appear under the same heading, না এগুলো সব under the heading motion হয়ে যাবে কিন্তু কোনোটা same heading হবে না আগেরটাও তাই under the heading motion on same date 25th তাই তো বললাম 25 under the heading motion সব next
Item number 528.
yes
Madam, land was requisition.
who is appearing
I have some notice also. Upgradation also, sir.
did not serve the GP's officer you have served
The issue has been decided. I'm coming, madam.
so they may request none appears if it is the service none appears for the respondent if their appointment regular is please serve a copy to him
Yes.
both the matters yes what is the matter about same matter
No, same. No. Yes, ma'am. On land of the petitioner requisition, there was scheme abandoned. I filed a writ petition earlier for releasing of land, and your lordship directed to consider my representation. In considering the representation, they have released our land and calculated the compensation and sought for the same from the requiring body. But the requiring body is not placing the fund, the payment is not made. And kindly see your lordship similar decision is page 52, madam.
where is the order of the representation Mr. Dey, do you want to see and come back
Well,
let
already,
him serve him a copy let him
already,
go through the record
already they admitted they have supplied that money has been sought for.
এটা দেখাও না
Money has been sought for. Shaktipada Madhuri, sought for.
My lord, the requiring body will pay the amount within certain time.
Yes,
After
yes,
that, my
this
lord,
is the order, my lord. Can
that
you
will
see?
be the order. Yes, my lord.
Page 52, my lord.
52 is the order
No,
Your lordship's order.
order, lordship's order দেখাও না, এটা দেখো,
the representation's order
representation টা দেখো।
But representation, I have annexed the amount, well, calculated amount, that has been supplied by the RTI application. Page 44. Page 44, serial number 4.
Then my lord come after petition.
Yes.
this you cannot make out what was decided in the representation
Yes, yes, they have released. Kindly see, madam, they have released my land. Kindly page 38.
page 38
38, this is the deed acquisition release order. Thereafter, I made an application under RTI, status of compensation. They have supplied, kindly see my page 44. Page 44, serial number 4. Shaktipada Madhuri, date of letter of placement of funds. And thereafter, he made a demand notice.
তিরিশ পাঁচ 40,000
No, it was which land.
কার কাছে চেয়েছে রিকভারি বডিটা কি
Same issue, my lord.
where is it recorded that it will be paid upon placement of fund by the concerned authority that should be recorded in the order of the representation order disposing of the representation?
That will, you will not get that, my lord, according to the page, এটা কত 44, my lord. Item number 4, my lord. From
Scale.
1, 2, 3, 4, in 5 lines, my lord. Memo number is there, my lord. 11,
Will there be a direction for placement of fund?
yes, my lord.
But this is the order. Kindly see my your lordship's order, my lord.
বাবা, ঠিক আছে।
Kindly see my lord.
Affidavit
Yes,
of
my lord.
service. None appears for the respondents. Mr. Their appointment regulars করুন, copies of the direction.
Memo
The
number এখানে আছে।
petitioner's land
এটার মধ্যে memo number
was requisitioned. The same project, Mundeshwari.
Yes.
For construction of Mundeshwari embankment under the provisions of the West Bengal Land within bracket requisition and acquisition bracket closed Act 1948 by the state respondents. Stop. The project was subsequently abandoned and pursuant to where is the earlier order of this court?
Yes, my lord.
Pursuant to an order passed by
Page 26. Several matters, including this matter, were disposed of by your lords. WPA 1469.
pursuant to an order passed by this court on December 10, 2021. Which matter is the petitioner's
In
matter?
WPA 1469, page 28, last matter.
Shaktipada
Madhuri.
In WPA 1469 of 2020, along with other writ petitions, directing the state respondents to consider the representation submitted by the petitioner within a stipulated time frame, comma. The page 38 is the release order.
38.
The concerned authority, comma, upon consideration of the representation submitted by the petitioner, comma, issued release order in favor of the petitioner, and physical possession is handed over.
Yes.
And physical possession of the plot in question was handed over to the petitioner
On 13th of
on
April.
13th April 2022. Stop. The concerned authority was unable to pay the compensation to the tune of rupees 81,274.
374.
81,374 to the petitioner, since fund was not placed before the authority by the irrigation department. Who will place the fund?
That is the principal.
Respondent number 6.
By the principal secretary, comma, Government of West Bengal, comma, Irrigation and Waterways Department, comma, being the sixth respondent herein.
To the respondent.
Petitioner seeks.
To the respondent number.
The petitioner prays for a direct praise for a direction upon the sixth respondent to release such fund in favor of
Respondent number 2.
the second respondent, district magistrate.
Yes.
for disbursement of the same to the petitioner. Paragraph learned counsel for the respondents submits that the sixth respondent be directed to release the fund in favor of the second respondent in accordance with law. Paragraph in view of the above, the writ petition is disposed of, directing the sixth respondent to place the required fund no request was made by the second respondent to the sixth respondent.
Yes, my lord, as because
document is not there.
in that, my lord,
Fund one thing, I'll say
and one thing, my lord, there is a memo number is
letter of
there.
placement of fund.
There is memo number is there, my lord. That memo number is with us, my lord, not you. Memo number is there, my lord. Date and memo number.
He will place the required fund in terms of
Memo number.
memo number.
Memo number.
It is not very legible. Please say the
1186 by 18.
1186 by LA.
LA.
Date was at 30th May 2022.
2022.
30th May 2022.
this is the LA case number.
Yeah. No, my lord, that is a memo number by that memo, my lord, money was.
Please see the heading LA case number.
Mar, they are this following their system, manner. Yes, yes.
In the
This is their system.
report, it is LA case. It is not the memo. 7273. That is LA case number.
No,
Yes,
my lord, that
this is their system or LA case. Yes, LA case.
Yes, my lord, that
Or
is
it will
the
be requisition case.
My lord, that is the next, my lord. এটাতে আসবে।
Or kindly direct as sought for.
These are not LA case numbers.
Or as sought for.
Three, my lord.
কি বললাম লাঞ্চ?
Date and এগুলো কিছু
In terms of category, required fund before the second respondent within 2 weeks.
2 months, my lord. As because, my
Fund
lord,
will be placed within 1 month.
2 months, my lord. As because, my lord, money will be taken from the finance department.
Within 2 months from date. Stop. The
Finance department
second
থেকে
respondent is
Request
directed to
2022.
disburse the amount in favor of the petitioner.
Yes.
Disbursal within 2 weeks.
Yes, my lord. Disbursed.
Within 2 weeks from the date of receipt thereof. Disposed of.
Get
Continue with the mentioned matters from after 2 p.m. also.
But under compelling circumstances, I am mentioning a matter, item number 274.
570.
Sorry, 573. This is a fresh writ petition on the basis of your lordship's earlier order. DM was directed to consider my complaint of filling up of a pond in my property. There is a pond which is being filled up. And on that basis, your lordship directed a DM to convene a hearing. Well, then hearing was held. Thereafter, DM directed an inspection. Whatever happened in the inspection, my lord, no noting was done. No minutes were given to us. Suddenly, we are communicated that BLRO has made a suo motu prayer to the DM without reference to us, and an order has been passed by DM for measurement. BLRO has fixed measurement, my lord, today and tomorrow. And my lord, my client is a very aged lady. She resides in Calcutta. No representative
I think the matter was mentioned in the morning.
Yes.
Protocol,
Not today.
protocol.
Yesterday it was mentioned.
Short
my lord,
service actually.
for short service. So if
Also, I think.
Yesterday, my lord. Your lordship granted leave to short serve. We have already served upon them. I am told, my lord, the persons are there at the spot today. I am only praying this. My lord, the measurement exercise for the time being be deferred. Your lordship will hear the matter.
How will you be prejudiced if it is measured? It will be taken up
Well,
in any case after the vacation?
Yes, but only thing is that we are unable to attend in such short notice.
Let
And
me measure, it will be set aside if it's not within
only
your
not only that, but your lordship, I will show your lordship. It is a
measurement is not really prejudicial to anyone.
Our
Right.
private property.
my private property.
BLRO measure.
That is what it is. And BLRO has not
I don't
issued
what
notice
what
to me.
basis?
Your lordship's order is restricted on DM. DM has passed an order that there will be an inspection. Inspection was held. Thereafter, no further record of inspection.
In a day before appear before the vacation bench? Because
well-
now I can grant you leave.
आज के और कल
Today
के
will not be possible. Tomorrow also
measurement
it will be difficult. So
Well, the
can
only
grant
thing is
leave
that they will continue, complete the measurement today. Well, ex parte they will.
27th is the vacation bench. You can appear before the vacation bench if you want. I can grant you leave.
Tomorrow, my lord, kindly grant such time, my lord. Tomorrow, we will not take much time, my lord. Tomorrow in the morning, if you
You are not mentioning upon notice.
I will give
It
them.
is appearing as a mentioned matter. Let me see if I can take it up. I will.
But
It is already
mention matter
mentioned
appear.
Yes,
So if I am taking up mentioned matters now also after 2
And
p.m.
in case it is not called on, kindly take it tomorrow. Give some precedence tomorrow.
Let us see.
Akbar mention. May I renew my prayer at the time of your lordship's rising, my lord?
In case.
In case it is not
Put the number to him.
573 to the WP number to and I am going to I intimate my lord the government pleader also.
Yes.
Now, calling from to the list 529. Am I that?
789.
I am for the petition only. I am for the state, my lord. My evidence.
Yes.
This matter relates to unauthorized enforcement on the government land. Initially, the petitioner moved a writ petition before this honorable court on the basis of apprehension that the land belongs to the PWD, Public Works Department. Thereafter, my lord was pleased to pass an order directing the authority, BLRO, to demarcate the land. After demarcation, it was found.
Wait a minute. You are appearing for all the private respondents? 789. What about the others?
I have served and they have received. Only two return.
এটা 538 লিখেছেন তো ম্যাডাম আইটেম নাম্বার 529 চলছে আপনি লিখেছেন 538
Yes.
And thereafter demarcation was made and that was found that the land belongs to the government land. And thereafter the
assistant engineer wrote a letter to the subdivisional officer to take necessary action, but that has no action has yet been taken. That is at page 31. May I read you?
No, I've got it. I've seen it. So it's government land.
Government land. Now, I would humbly submit that the petition is premature because the Lordship directed demarcation. Demarcation was done. From demarcation, 2 months time was given for my lord completing the proceeding. Now, my lord, on 2nd of August, my demarcation was done and report was prepared. So the period expires on October 2nd. He has filed in September 21st.
But now,
Now it has expired, my lord. True.
No.
I humbly say, so he has no cause of action for filing the writ petition. Authorities have to take in terms of the previous order. They have to. They will take steps. I don't know. I don't have the instruction today right with me, but they will have to take steps. But
that was
what is the so hurried up the petitioner, my lord?
No.
Somebody
That
to
is
vacate.
not true.
Let the period expire.
My learned friend probably failed to understand the
period has
meaning of the
expired
decision.
as on this date.
As on this day, it has expired.
This
So
submission is immaterial.
And apart from that, that was
so far as filing the petition, my lord,
that
there was no
petition
cause of action.
was
But
filed against the PWD officer.
current status, I can my lord,
Say
file.
that as on date, if it is mature, we
My
can
lord,
take it.
my lord.
Yes.
My lord, kindly, because I don't have today's status, current status I don't have. Kindly, my lord, keeps up the vacation. I'll take the instruction.
Against the
What
land
is
of
the-
Public Works Department. That writ petition was filed against the Public Works at PWD. And this is against the subdivisional officer, government land. That is Unauthorized Occupation Act. And that was State Highway Act. Earlier writ petition.
It is found that the land belongs to the government.
Yes.
That's
So-
why this writ petition was filed.
Steps be taken.
Yes, they are taking steps. You know, I don't know the current state. That is why I'm saying keep it after vacation. In the meantime, because
File a report.
everything is apprehensive. Whether they're taking steps or not, he has already demarcated in terms of your lordship's order. So it's apprehension only. I'll come back.
So authority has to initiate proceedings.
So I don't know whether they have initiated or not. Kindly give me some time. I'll come back with the instruction.
Affidavit of service. None appears for respondent numbers 10 and 11 despite service. Paragraph, the petitioner alleges encroachment upon government land. Stop. Paragraph, learned counsel for the petitioner takes this court to a communication. The letter is at page?
Page 31.
A communication made by the assistant engineer, plus C highway subdivision within bracket, subdivision, PW within bracket roads, bracket flows directorate to the
Respondent number 3.
subdivisional officer, Tehotto on 3rd August 2023, which demonstrates that the plot in question is that the plots in question
Or rather,
are
your lordship will
recorded.
dispose it of directing the authority without giving a time. That is better, my lord. Because again, I'll come back. My lord, kindly dispose it of. Giving some time.
Recorded in favor of the collector, Nodia. Paragraph. It is not clear as to whether proceeding under the West Bengal Public Land within bracket eviction of unauthorized occupants bracket closed Act 1962 has been initiated by the authority pursuant to such demarcation. Paragraph. In view of the above, this court is inclined to hold that since the plots in question appear to be government land and the petitioner alleges encroachment of the same by the private respondents by raising unauthorized construction therein, the concerned authority
Respondent number 3.
3.
being the
Subdivisional officer.
third respondent herein, be directed to initiate proceedings under the Act of 1962 and take the proceedings to its logical conclusion within 3 months from the date of, let it be 2 months, because demarcation is over.
Demarcation
Within
is done.
2 months
We have
from
to
the
give,
date of
we have to give them a hearing and they might appear and they might produce evidence.
sufficient. Along with demarcation, it is 3 months. We say 3 months. So when the demarcation part is over,
Because after this, we direct them.
observe.
There are 3 stages. We direct them to remove. They don't remove. Then, my lord, we initiate a proceeding. They come, give evidence, and order is passed. That is why, my lord.
2 months should be sufficient.
My lord.
2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with law. শুরুতে heard learned counsels for the participant. Disposed of?
Within 2 months. Much obliged.
Next.
Item number 530. Madam, for the petitioner, my lord. The second round of litigation, my lord, and my land act. My lord, I have served the respondents, my lord, as well as while mentioning my
Service.
affidavit of service. This is my affidavit of service, and my lord, while mentioning my lord, I have sent the. About.
Supplementary.
Huh? Oh, supplementary.
The Union of India National Highways.
My lord, National Highways,
Competent authority is the
competent
district
authority.
judge. You serve all 3 of them?
Yes, my lord. According to the tracking report, my lord, all served. My lord, address is delivered. On 3rd of October, my lord. All.
Why Secretary Transport Bhavan?
Transport. My lord, Union of India Competent Authority and my lord, Project Director, National Highways.
You have not served the Union of India?
Union of India, my lord, the Secretary, my lord.
The Secretary Transport Bhavan?
Yes, my lord, according to the
Ministry of Road
address.
Transport and Highways.
Yes,
Right.
yes.
And I do not find any of the respondents today. Will you come back after vacation?
My lord, the problem is, my lord, the land is, my lord, now acquiring, my lord. My property, in front of my property, working is going on. And the walls, my lord, of my building is, my lord, there is a cracks. The building may fall, my lord, any time. So, my lord, till that time, my lord, stay in front of my building, my lord. The work may be stopped till that time, my lord.
Not
That's otherwise, my lord.
Public work cannot be stopped.
But they are residing there, my lord. No compensation received till date. My lord, kindly come to page number 69 of your lordship.
And you say in front of your land.
Front of no, my lord, my land also acquired, my lord. But since the matter is going on, it is pending before your lordship. They do not come, my lord, to my land, my lord, for acquisition. But they are, my lord, working in front of my land at very close vicinity.
The construction is going on in the acquired portion of the land.
Yes. No, my lord. My land was also acquired. But since the matter is going on, this matter is pending before your lordship.
Construction is going on which land?
Just vicinity in front of my land.
That land is also acquired land.
Acquired.
Yes, so you cannot stop construction. Please come back after the vacation.
But on 2nd, my lord, I'll send notice.
Second, I'll give you a date.
Or my tomorrow, my lord, so that tomorrow.
Let it appear on second.
Second. Perhaps to mention matter, my lord.
Affidavit, no. Affidavit of service. None appears for the respondents despite service. Paragraph, let the matter appear under the heading motion on 2nd January 2020.
But once I have affirmed and supplementary affidavit, may that be kept on record, man.
Let the matter appear at supplementary affidavit submitted on behalf of the petitioners taken on record. Petitioners. Next matter.
Item number 531.
My lord, I am appearing for the petitioner. I have served upon all respondents. My lord, I am submitting affidavit of service.
Second.
Only state is there.
Yes.
Only state respondent.
Only stated.
Yes, what is the matter about?
My lord, a land was requisitioned in the year 1980-81 by Act number 12 by the District Magistrate Bankura for the construction of rest house and pump house at Joyrambati. Thereafter, my lord, hearing had been held before the concerned authority in connection with plot number 603, 603, my lord. Thereafter, my lord, petitioner made a representation before the Office of the Government of West Bengal Assistant Engineer PHE, Bishnupur Subdivision, Post Office, Bishnupur District, Bankura, my lord. Page 38. Kindly see. Page 38 representations.
Where, what are you asking for?
To release the compensation amount with regard to the plot in question, my lord, according to market value. A similar order has been passed by this honorable court in a similar matter. I have annexed this order. My lord. Page 53, Lordship's order.
The acquisition proceeding is completed?
Yes.
May I submit?
Yes.
The petitioner's land minor requisition, thereafter, my lord, the proceedings has not been completed. But the PhD department utilized the land. He made representation before the authority. Accordingly, my lord, the representation, my lord, your lordship, kindly turn to page 34.
34?
Page 34 of the requisition. P10. Petitioner was asked to appear before the authority, my lord, along with the documents regarding compensation. But no decision has been taken, my lord.
Taken.
And in similar circumstances, my lord, your lordship has pleased to pass an order, that is P13, which my learned
Yes.
is referred.
Yes.
P13.
Page
P13. My lord's
P13.
order in respect of similar plot.
Similar plot. Similar order.
Oh, here as a notice of hearing was issued.
Yes.
Hearing concluded, but no
Yes.
decision has yet
Has
been
been
taken.
taken.
Let it be concluded, my lord. P34.
Hearing is concluded.
Yes, hearing already
Only the
complete.
decision has not been communicated.
Yes, yes, yes.
So let that be communicated.
Yes, yes.
Yes.
Affidavit, please.
Affidavit of service. It is submitted on behalf of the petitioners that the state respondents issued notice under section 3 of the West Bengal Land within bracket acquisition and acquisition bracket closed Act 1948
decision हो हम तो कुछ कुछ नाम तो तुम्हारे फेवर ही बोल रहा हूँ
for requisition of the land of the petitioners for construction of pump house and rest house under water supply scheme at Joyrambati area. The land has been admittedly utilized, but no compensation paid to the petitioners for the same. Stop. The petitioners submitted an application with a representation before the concerned authority requesting payment of compensation pursuant to which page 34 is the notice.
My lord, that is the notice, my lord. Petitioner was asked to appear, hearing notice, and accordingly he appeared. Page 34.
Pursuant to which the petitioners were directed to appear before the authority by a notice issued by the Special Land Acquisition Officer, Bankura, on 2nd November 2021. Stop. The petitioners appeared before the authority and hearing on the relevant date, and hearing was concluded. Stop. But no order has been communicated to the petitioners till date. Stop. The petitioners pray for a direction upon the concerned authority to communicate the order to the petitioners and take necessary steps for disbursement of compensation in their favor. Present market value.
Yes.
That is his claim, my lord.
His claim.
My lord's order is
My
my
claim.
otherwise. My lord's order P13 is otherwise.
My lord,
Playing similar order.
according to present market value.
Consider learned
Land acquisition,
ল্যান্ডেশন তারাটা করবে কি করে? ল্যান্ডই তো অ্যাকোয়ার হয়নি।
special land acquisition.
special land acquisition
It has not been
officer had
acquired.
been
The PhD
taken
department
hearing.
will consider, my lord. They have utilized the land. The land is not
In
acquired.
earlier matter, my lord, land acquisition.
আরে করলে কি বেটা? ল্যান্ড অ্যাকোয়ারই তো হয়নি, ও দেবে কি করে?
The executive engineer.
এক্সিকিউটিভ ইঞ্জিনিয়ার।
Fifth respondent. Learned counsel for the respondent submits that
My
the
lord.
fifth respondent be directed to
ফিফথ রেস্টুরেন্ট।
to comply with the order passed by this court. Paragraph in view of the above, the petition is disposed of directing the fifth respondent to communicate
that-
the order.
Well, my lord, may I submit one thing, my lord? There is wrong something. The notice was issued by the earlier, my lord, P30 for the special land acquisition.
Officer, yes.
Therefore, decisions will be taken by the special land.
Special land
So the
acquisition.
fourth respondent.
Yes.
Fourth respondent.
Respondent number 4, my lord.
Yes. Disposed of directing the fourth respondent to communicate the order passed by him in connection with the application made by the petitioners. Within 6 weeks is not required.
As your lordship.
Communicate the order. 4 weeks.
6, my lord, it is.
Communication of the order. 4 weeks.
As your lord.
4 weeks from the date of communication of this order. Paragraph in the event the petitioners are found entitled to compensation, such compensation be disbursed in favor of the petitioners within 2 months thereafter.
Yes.
Disposed of which?
Good.
Grateful, my lord.
My lord,
Yes,
for the state respondent.
So I am number 532. So I am for the petitioner, lordship, the affidavit service. Lordship, unauthorized construction by the private respondent on PWD road, just blocking my egress and egress. Paragraph 6, I have stated. The private respondent refused to accept the summons. Paragraph 6.
However, my lord, he's in his everything is right, but he in his prayer he has implicated only police inspector. But police is not authority.
You are appearing for the state?
State, yes.
Anyone for the private respondent?
Private respondent, I have doubtless they have disused.
Both have refused.
Yes, yes. Lordship, your lordship's division bench judgment, I am going lordship with my lord
Division
justice.
bench judgment.
Yes, with my lord justice Sanjeev Banerjee. Lordship, kindly, the second page, bottom, last paragraph. And third page.
Yes, how is it similar to the present petition?
Because if the government, they have constructed on government place, the government should protect and there is no.
This is not required at this stage.
They have refused to. They have nothing they have showing before the lordship.
Have
They have some papers regarding their
Has
construction.
the government refused to consider your representation?
No, government.
Then?
Lordship, private respondent has not come.
Private has
Obviously.
not, they have nothing. Private has
But actually, my lord, as per section 10, subsection 1 of yes, Highways Act, West Bengal Highways Act, only respondent number 4 is responsible for the same to remove the encroachment.
DM is the head of the
এই তো আপনাকে
to shape the
চাইতে
government.
হবে।
Where is the representation?
My lord, this is the last page. Lordship, page 35. Page 35.
The fifth respondent will deal with it.
Uh,
Assistant engineer.
Yes.
This is a demand of justice. This is not a representation. Where is your representation?
Lordship, page 35.
This is a demand of justice. That is not a representation.
Lordship,
court
kindly
will not
consider the
direct-
demand of justice as a representative because
No,
pair.
not at
Lordship,
all.
kindly see the pair. Lordship, kindly the pair of the
The court
letter.
cannot direct disposal of a demand of justice.
Lordship,
Will
kindly.
you file a fresh representation before the authority?
Yes, I should. If Lordship direct, I should.
Because you have no other representation, isn't it?
Lordship, Lordship,
There should
kindly.
be first a representation and then a demand of justice, isn't it?
Demands, Lordship, kindly come to the page 37. 37.
Yes.
Kindly see my pair. Oh, you are requested to demolish the unauthorized construction made by Nitu Haldar
Not
and
your prayer, it has been made by your advocate on your behalf.
yes,
This is a demand of justice. There should be first a representation and then a demand of justice.
Yes.
You have directly involved your learned counsel.
on instruction. On instruction, I have
Maybe, yes.
instruction.
It's always on demand of justice is always on instruction.
on instruction.
Please file a representation before the authority, which will be considered within a stipulated time frame.
Lordship,
Yes.
kindly give direction.
Right.
Kindly give positive short time. Lordship, they can
3 months because evidence needs to be recorded.
everything.
Demarcation, then evidence, isn't it? Section 10 has to be initiated.
Yes.
Affidavit of service. Paragraph service upon the private respondents have returned with an endorsement, inverted comma, refused, which amounts to good service. Paragraph. The petitioner claims to be the recorded owner of the plot in question and complains that the private respondents have raised unauthorized construction by encroaching upon a portion of PWD road adjoining his property, comma, thereby obstructing his egress and ingress. Stop. The petitioner seeks to submit a comprehensive representation before the concerned authority in this regard and prays for a direction upon the authority to consider the representation at the earliest and take necessary steps for removal of such encroachment. Paragraph. Learned counsel for the respondents submits that the fifth respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the writ petition is disposed of with liberty to the petitioner to submit a comprehensive representation before the fifth respondent within 2 weeks.
2 weeks.
Within 2 weeks from date. Stop. The fifth respondent is directed to
Representation.
consider and dispose of the representation within 3 months from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with law.
Also, one pair.
Disposed of, which are-
If they have found this is unauthorized, so rather they take steps.
Automatically.
Lordship, your Lordship direction is most vital.
In the event, paragraph 4, in the event encroachment upon PWD road or any portion thereof is found, comma, the authority shall take necessary steps for removal of the same
Time.
in accordance with law within the stipulated time frame.
Get
Right.
Taরপর dispose of. In the event এর পরে comma দেবেন না। In the event এর পরে comma দেবেন না।
Item number 533.
আপনাকে নোটিশ দিয়েছি, সার্ভিসও করেছি।
Yes.
Well, the challenge is that to a decision taken by the registering authority.
Service upon the private.
Madam, for the private.
You're appearing.
Bye.
There.
Respondent number 5.
And the state?
Mr. Day is appearing. I have notice. Upgradation notice of দিয়েছি আপনাকে। Service notice আছে না। Upgradation notice also served, Mr. I have inquired from the office of the government.
GP's office is served, Mr. Day. Please appear. Please serve a copy to Mr.
Mr. Day is Mr. Day is already engaged in this matter by the government filter, and I have served the upgradation notice also.
Yes, what is the matter?
I'll tell you, Lordship, my lord. I am the owner of a land. My lord, I take a decision to sell my land. So I enter into an agreement with a private respondent for selling my land. So a consideration has to be paid. So he pays part consideration, but the balance is not paid. I execute a conveyance, but when we go to the registering office, the registration office where the registration is done, usually the balance money is paid and the registration is done. My purchaser, which is the private respondent, does not pay me the balance consideration. So I don't do registration. So at that point of time, registration fails. It refused because the vendor has to be there. The vendor is the principal party in a document of transfer. Then I receive a notice, if your lordship will come to the first annexure, which should be page 12.
Yes.
This is allegedly a notice under section 74. I'll show my section 74 does not contemplate such a situation. Section 74, here it says, my lord, in connection with the above noted subject and with reference to the letter of Durga Manna, which is my purchaser, dated such and such, which was received by the office, she hereby requested to appear undersigned chamber such and such. So thereafter what happens, there is one more notice which I receive on the next page, 13th of September, where the date is changed. Initially it was 26th. Could not be heard, so there. So I immediately come up and challenge these two notices in the writ petition. In the interregnum, what happens is, my lord, the registering authority proceeds and decides that this is an appeal under 74. I exercise my authority and I direct registration to be done.
Where is that order?
My lord, it has happened during the course of pendency of the writ petition. My lord, we've obtained certified copy. This is the, I'll just indicate to your lordship. Orderটা কোথায় গেল? এটা দিয়েছে। Orderটা কোথায়? I'll just take out the relevant page.
Challenge the proceeding
Yes, this is the order.
annexing the order.
No, my lord, this order was passed during the pendency of the writ petition. Challenge is the two notices. You don't have the jurisdiction, authority. Well, today, if I am the vendor and I refuse to go to registration, well, this is not a civil suit. This is not a decree for specific performance.
Order also, please come to your prayer A.
My lord, prayer A. Stand corrected.
Not to give further effect to the order passed in the proceeding.
No, if your lordship will see, give any effect to further effect to order passed in the proceeding based on 2(8). So well, this is the notice. This is when I came to the court.
And quash and set aside the entire proceeding as well as a notice. So you have even asked for setting aside the proceeding, which was not within your knowledge at that time at all.
No, I had knowledge of the proceeding because I had notice. I had notice of the proceeding. But the order came to my knowledge much after the filing of the writ petition. So the initiation of the notice, the two notices which I received, on the basis of which the authorities were exercising their jurisdiction to entertain the prayer for registration of my conveyance, by which I am selling the property. So that was under challenge. Our specific challenge is that at this stage you don't have the jurisdiction to direct registration. It is a civil dispute.
Notices are culminated into the orders. So
My
it's a
lord,
separate
my
cause
lord,
of
my lord.
action.
Yes. Now, my lord, we have to. That's why, my lord, I say that, my lord, we have to now bring on record the notice and
As well as
by
the
way of a supplementary affidavit.
the order.
Yes, absolutely.
Supplementary affidavit help, or we have to file a fresh writ petition. This is a separate cause of action altogether.
My lord, arising
That is no meaning at the moment.
at the moment, because based on the notice an order is passed, and if your lordship will consider, if an order is passed based on a notice and I have challenged the authority to issue the notice. So if the notice, issuance of the notice order proceeding under 74 is held by the court, hypothetically, to be without jurisdiction, so the order will automatically become a nullity. Or I can make an suitable amendment to the writ petition. Just add a prayer to the writ petition.
Becomes a completely different cause of action.
My lord, if I may, my lord, is subject to correction.
Let us see.
Yes, because why all he has done today, he directed registration and the registration has happened. So that means today my property, the title of my property has transferred. So tomorrow, unless this person, unless the registration authority's order is restrained or stayed, he will create some third party interest, because today he is the owner effectively in the eye of law, because the registration has happened in his favor. Because I say that I haven't got the balance money. So the question of me executing the document or being present at the time of registration does not arise. He doesn't consider that. He passes an order, records everything, but there are other issues also. I'm sure I complete very well, my lord.
But
And my lord,
petitioner
only one
executed, my lord, signed, executed the deed, and my lord, consideration money has been paid. My lord, kindly have a look to the check.
The entire consideration.
Entire consideration, and now he is playing tricks. My lord, kindly have a look. And my lord, the registering authority under section 75 orders my lord, registration. If the registrar finds that the document has been executed, and
This is 2 lakhs. What was the total?
enter 10 lakhs already amount has been paid, and 2 lakhs on a balance consideration that has been paid. And my lord, the order passed by the register of assurance that if execution is done, then my lord, the registering authority can register the document. My lord, section 75 may I place before your lordship. If the registrar finds that the document has been executed, when the execution has been done, and that the said requirements have been complied with, that has been done, my lord, registering authority will see identification, my lord, execution, consciously execution, yes, appeared before the registering authority, consciously execution and passing of consideration money. My lord, that has all been done. And that's why, my lord, registering authority directed to document to be registered.
Well, kindly
My lord,
take
this is
72
my
and
lord, 75.
73 sections
Let the
70
My lord,
come on record. Very
yes.
You can take this back for the time.
Yes.
My lord, since now he is the owner, my lord, kindly direct that he should not create any third party interest. Otherwise, this entire effect will become a
Showing that the
Yes,
consideration.
no, not paid. Well, if I consider, my lord,
Yes, but-
consideration is paid, where is the question of not executing it? If I have paid the consideration, it's a concluded contract. That means I say I did not register because you did not pay me the balance.
But he playing tricks.
No.
But entire money has been
Now,
paid.
who is
Your
playing the
lordship,
tricks?
kindly
This
see.
has to be decided.
Yes, yes.
That's the whole thing. I am not saying that title has already conferred upon him, so he should not create any third party. So I have to.
With your supplementary affidavit.
I will,
please
my lord.
serve
I
an
will.
advance copy to
I
the
will. But at least the third party interest. Otherwise, everything will become a exercise in futility. My lord.
The order is not on record at all. How can I direct them not to create third party interest?
No, what I'm trying to say is that, my lord, what I'm trying to say is that in respect of the property, at least the registering authority should be directed, because not to register any further instrument in respect of this property. Otherwise, I kindly appreciate. But today he is the owner.
Come back immediately after vacation.
Very well.
we'll
Very,
deal with
very well.
Learned counsel for the petitioner seeks to use a supplementary affidavit annexing relevant documents pertaining to subsequent events. Paragraph, let the matter appear under the same heading on 17 January.
Grateful. Lordship has given us leave to file a supplementary affidavit.
Yes.
Yeah, great.
Respondent number 5.
Great. The bench.
Item number 534.
But I am appearing for the petitioner, my lord. I have served upon all respondents, my lord.
Homeland.
I am submitting affidavit of service.
Who seeks to file a supplementary report on prayer of the petitioner, leave is granted to file a supplementary. On prayer of the petitioner, leave is granted. Yes. Mr. Dey is appearing. Jila Parishad, Panchayat, have you served?
Yes, all parties I have served. They have duly received, my lord.
এখন কত 534 হবে
Yes.
My lord, Sojoldhara program is an extension of reform initiative. It is a reform initiative, my lord. It is a powerful step forward to supply drinking water to the water scarce villages within the shortest period of time or at least cost. My lord, Sojoldhara program 1 and 2 that can be implemented by the state through panchayat, blocks, or district wise, my lord. Recently, the petitioner has come to know that a Sojoldhara program has been setting up on the land of the petitioner. Kindly see the lands. Page 13, record of rights. My lord. Got it, my lord? Page 13.
Yes.
Got it, my lord?
Yes.
Plot number 590, HAL plot number. My lord, classification of the land is Pukur part. On the Pukur part, a Sojoldhara program has been establishing by the state. My lord, in this respect, I have made a representation before the district magistrate Bankura for taking steps and not to construct on my land. As my lord, there is no vesting proceeding initiated against me, no due process of law. State government has acquired the land, but trying to establish a Sojoldhara program project on my land, my lord. Kindly dispose of the said representation, which is pending before the district magistrate.
Yes.
Yes. Yes, my lord.
Affidavit of service. It is submitted on behalf of the petitioners that a project under the name and style of Sojoldhara program for providing drinking water to villages having scarcity of water is implemented. The state government through local bodies like the panchayat, etc. The petitioners have learned that such program shall be scheme shall be set up in the land of the petitioners, though the said land has not been acquired by taking recourse to law. Stop. The petitioners submitted a representation in this regard before the concerned authority on 5th September 2023 requesting the authority to refrain from setting up such scheme in the petitioner's land. Stop. The representation is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the state respondents submits that the second respondent be directed to consider the representation in accordance with law. একদম শুরুতে যখন affidavit of service বলেছেন তারপর একটা লাইন করুন now appears for the 10th and 11th respondents despite service. 10th and 11th respondents. In view of the above, the petition is disposed of in view of the above. Directing the second respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 1 month.
Yes, ma'am.
Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioners, comma, in accordance with law.
Grateful, my lord.
Disposed of.
Well,
Next.
that's my application, my lord.
Item number 535.
Yes. You're appealing for state.
Lordship, I appeal for the respondent number 12.
I am for respondent number 8.
All other respondents are here, my lord.
It's not there, bad luck. Please come back after the vacation.
My lord, it is very simple matter, my lord. Matter can be, my lord, disposed of.
Heard whether it is simple or complex?
Or, my lord, let it to tomorrow, my lord. My lord.
No.
I have served, my lord, notice to all the, my lord, respondents, my lord. This is very-
It's not.
Your Lordship, I should point out that prior to mentioning the matter or bringing the matter under mentioned matter, notice was not served.
Notice served করেছে, ঠিক আছে? My lord,
Only the state, I believe only the state has been served.
to all the respondents, my lord, I have sent, my lord, with my lord, by post, my lord. My lord, can you see my?
Then it was served after mentioning.
Definitive of surveys.
No, my lord.
The mention.
There are two services, my lord, two services. One service, my lord, for affidavit service, and another affidavit service, my lord, regarding, my lord, notice relating to, my lord, upgradation of the matter, my lord. My lord, what happened, my lord?
State is not ready today. Please come back after the vacation. Affidavit of service.
Ready হয়ে গেল।
On prayer of the state respondents, the matter is
আমরা তো
adjourned.
appear করছি
Paragraph,
তখন আর-
let the matter appear under the same heading on 22nd January.
Lord, I have a আমরা শুনিনি কি affidavit direction দেবে। Lord, is keeping it on 22nd of January.
Yes.
Sir, I have a personal difficulty on the 22nd.
Will you come back 24th?
Any other day barring the 22nd.
24th. 24th.
24th January.
Happy problem. No.
Yes, next.
এই problem. ये হচ্ছে নাকি? আপনার কি? ও আচ্ছা। Item number 536.
6 I am for the petition. The innocuous prayer for consideration of the representation of the facts narrated in the paragraph 4. That's why the representation was made before the authorities that has not been.
35.
Lord, the paragraph I have stated, paragraph 4 I have stated. Lord, the petitioner is the owner of the landed property and adjacent plot is the a nala is situated. Only for egress and ingress a sako is required. But that's for the purpose of no objection, unless the no objection given, then they cannot be done. Only
You
prayer
ask
for,
for permission.
yes, no objection or permission.
My lord, there is a representation, my lord.
After holding in,
My lord, page 15, my lord, and it's at P3.
let the man after holding inquiry.
My lord, it's all right, my lord, but my instruction is, my lord, and also petitioner has admitted, my lord, in the second
that's true.
paragraph, that আমি আপনার ইরিগেশন রোলের উপর দিয়া জল নিকাশি রাস্তা রাখিয়া চলাচলের জন্য রাস্তা নির্মাণ করিয়া চলাচল করিতেছি, যাহাতে আমার চলাচলে কেউ বিঘ্ন না ঘটায়, তাহার জন্য আপনার অনুমতি নেওয়া আবশ্যক। But he has stated that he want the no objection.
Oh,
He
that's
want
true.
already he has constructed, my lord,
Without the.
Not
without
the
permission.
construction. This is the sako, my lord, relating to the bamboo or the wooden, my lord. This is not the.
That is not your land on
That-
which you have raised the.
No, this is the adjacent land is my land.
Admission, my lord, it is
This is
admitted.
this is admitted.
The bridge is not on your land.
Not the bridge. Only, my lord, the sako is the
Whatever, my lord.
admit.
Shako is a temporary bridge.
Temporary only canal, simple passage canal. This is the,
But there is
on
a
the other side the
plan,
road.
my lord, sketch, just be, just.
আমাকে বলতে দিন, আমাকে বলতে দিন।
My lord, kindly go.
আমি চাইছি তো হোল্ডিং ইনকোয়ারি করে আমাকে নো অবজেকশন দিন। If it is not there, is
I am not on the way, my lord.
Where is your prayer for no
Not in
objection?
the
that is a kindly prayer,
You
madam.
have stated that in
Not
your
standing in the
representation,
way,
you have
ma'am.
stated that you are already using the land. You have built the Shanko.
That is
So
my
that the others do not disturb you. That is your prayer, which
That is-
cannot be considered.
that whatever may be written in the representation, I cannot say. But the prayer is, my lord, kindly appreciate.
You
that-
must be able to say what is written in the
My
representation,
lord,
sir.
representation kindly appreciate after holding inquiry into the matter, giving the no objection or permission. This is the only prayer. Holding the inquiry, if it is, my lord, the necessary order be passed.
My lord.
What I have admitted. This is not the
admission
suppression
to
of
the
fact.
petitioner in the his representation, which is annexed, my lord,
That's
on
true.
oath, my lord.
আমি তো deny করছেন, that's why-
And in the sketch web, my lord, kindly find.
So have you first make the construction and then ask for a no objection?
Yes.
This is not the construction. This is, my lord, the not the,
A
a
shako
minute.
is a
Shako is a,
construction.
Shako is a, not the construction by Pakka construction is not.
Bridge, a temporary bridge.
Temporary and
Over the
bamboo,
canal. Yes.
not the canal. This is the only nala. Is the bamboo,
Got
is
it.
the
You are-
bamboo or
you are
wooden?
trying to make it simple, insignificant, but well, there is a nala in your terms, and you have constructed a shako on some other land without permission, and now you're asking for a no objection.
Not other lands, my lands, from the my lands.
It's adjoining. The shako is not on your land.
Shako is the,
Yes,
Shako
admitted
is
in his
over
apartment
the,
also, my
over the nala. Shako is over the nala. But land is my land.
Nala is not in your land.
Not, no, is not.
That is next to your
That is
land.
irrigation land. That is the made the representation.
Where is your in representation? What have you stated? Please see.
I've seen.
Then how
I've
is it-
seen.
it cannot be considered disputation.
My prayer is kindly appreciate to that.
My lord,
Then you
in
admit
his
that you have
apartment
done the
also he
job
has
of-
Kindly,
stated, my lord.
kindly, my lord,
Be dismissed. I'm sorry, sir.
kindly prayer, my lord. What I'm praying for.
Your prayer is contrary to your
No,
representation.
this is prayer for only for holding inquiry into
You
this
have
matter.
admitted in your representation that you have done the work.
No, that has been, my lord, the, I
So now
cannot,
there
I cannot,
be any inquiry, there cannot be any no objection. Remove that first and then come back to the court.
that order be given, that order be given, lordship's past order.
Not at all.
What
Why?
is the on record?
Dismiss your
Well,
case.
that is, the
Case 14, my lord, the case which is.
Madam, when the court
Darn.
speaks to you, please.
Yes, yes.
what is on record, record. I cannot change. The application is made by the client.
So you cannot change dismissal also. Since
That
there
is, that is,
between
that is
the-
before lordship. That is before
there
lordship.
is contradiction between your prayer
That
and your admission. This writ petition does not lie at all.
Not the only one investment. Only investment.
Okay.
Lord, the things, my lord, the prayer for my lord holding the inquiry in this matter.
I have to dismiss. No other alternative.
Then I will giving the liberty.
Liberty to what?
Given liberty to face a representation or my things, my lord.
Already.
Or my lord, the things. What is happening, my lord? I cannot change. Representation made by the
Shako
made
is
by the
there,
petition.
my lord, on government's land, my lord.
This is not the government land. This is the
Department's
You
land, my
have
lord.
admitted a wrong action on your part.
In his
your
paragraph,
representation.
my lord, yes,
that is
my
it.
After that, you
that is-
ask for a prayer to regularize it,
That is
which
the,
the court will not do.
that is my lord the what is record. I cannot deviate. Lord, the I'm submitting the lordship
Very
frankly.
Drafted writ petition which tries to regularize the wrong done by the petitioner.
Lord, I frankly submit. Lord, let the inquiry be held. And if it is so possible, giving an objection or to pass the reasoned order, nothing more.
Repetition of the submission will not help, sir. I'm sorry.
Then
You have
lordship.
admitted having constructed already. So the authority can take steps against you.
That's
You
right.
may dismiss the writ petition.
Lord, then lordship liberty be given to it.
Yes?
Liberty be given, my lord. If your lordship kindly, if you
Let him withdraw. Affidavit of service. The petitioner seeks to withdraw the writ petition.
Well, dismiss on merit.
Yes.
Dismiss on merit, my lord. Dismiss on merit.
Let him withdraw, let him come back, let us see. Because his admission is there, he
All
can
right,
go
all-
beyond it.
All right, as your lordship.
The damage is done, so let me not dismiss. Withdraw the writ petition and file a fresh writ petition on the same cause of action. Paragraph in view of the above, the writ petition being
Well,
WP
in this matter, my junior is also increased.
Paragraph liberty is granted to the petitioner to file a fresh writ petition on the same cause of action. Paragraph, there shall however be no arrest to cause Sergeant certified, etc. A further writ petition will also not help you, sir. I'm sorry.
No, not the
Next one.
next is my lord the same.
If you applies.
Item number 537.
Not the same.
You're
I'm not
okay?
in this matter.
Same, you have made the construction and then you're asking for.
That I
Same matter.
I checked it out, my lord. The same thing has been done. I checked it.
Non-prosecution.
Affidavit of service. None appears for the state respondents despite service. Therefore, seeks to withdraw. Same order. Huh?
Same thing has happened.
Same order. Next.
Much.
Item number 538.
I'm on behalf of the petitioner, my lord.
My lord, I am the owner of certain lands situated in Mouja Santoshpur under block Murari in the district Birbhum.
Have you served the private respondents?
Yes, all the private respondent has been served. May I, my lord? My lord, there is a dispute which has cropped up to the second appeal to this learned from the learned court below, that is Court of District Judge Birbhum, being title suit number 180 of 1974. And from there, a second appeal was preferred. My lord, if your lordship kindly see P1, annexure P1 in the page number, I will press this, my lord.
Initially, there was a declaratory suit.
My lord,
Initially, there was a declaratory suit.
there is the declaratory suit.
Yes.
There is the declaratory suit. Now it has come up to the stage of second appeal. And in the second appeal coordinated bench, my lord, in the page, in the annexure P1, my lord, I am pressing the annexure P1.
Page?
Page number 14.
Yes. Yes.
My lord, in the aforesaid SAT number 875 of 76 and civil rule.
The petition is maintainable. There, my lord, your lordship will come to the prayer.
Please, let me finish. Let me finish.
এবার বলবো, আমি বলে দিলাম এবার বলো। তারপর বলো।
Despite
Since
the
he is
order.
challenging the maintainability ground, he has the first right of audience.
Okay, okay.
Let us hear.
Your lordship.
My lord, if your lordship will see the prayer. A read of a nature of mandamus commanding the respondent.
This is under the Land Reforms Act.
Yes, my lord.
Yes. so
Refrain
this
from
court will
recording
not
any
be-
third party interest.
Yes.
And prayer B, my lord, it is the nature of mandamus directing the respondent to delete the name of the
What I will do, my lord, as because there is a judgment passed by the coordinate bench.
Approach the appropriate forum.
My lord, I have approached it several times. If your lordship kindly see my letter, I have gone to the Laji. I have run pillar to post, my lord, and I haven't find the present status. And that's why under compelling situation, my lord, I was compelled to file this writ petition, as because my land has been taken away. Even there is an injunction order, my lord.
This is under the Land Reforms Act, and this court doesn't have jurisdiction to deal with this. Any matter pertaining to the Land Reforms Act. This court cannot deal with it.
My lord, I am just for the time being, the restraining order should be passed.
The court doesn't have jurisdiction. Can a restraining order be passed?
My lord, Reed court has gone beyond the pleadings and everything.
Anything under the sun?
Please
go through the relevant act, sir.
My lord, I have.
Act, you are aware.
And I have gone through to some extent, my lord, but thing is that where I will go, I have gone to the department, I have gone to the Rajima court, they have stated that they don't have the records.
You have to go before the appropriate forum. Please find out from the act. I'll grant you liberty or have to dismiss on this ground.
Grant me the liberty.
Cannot deal with this one. The act is very clear now, specified act. Affidavit of service. Paragraph, the matter pertains to the West Bengal Land Reforms Act 1955. Paragraph, the petitioner seeks to withdraw the writ petition and file and take necessary steps before the appropriate forum. Paragraph, in view of the above, the writ petition being WPS such and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance. Paragraph, there shall however be no order as to costs as in certified website copy. Sorry, cannot get it. Next. Yes.
539.
I am for the petition.
The date?
Yes, well, yes, well, consider the representation to shortcut this matter. And your
What
lordship,
is the representation about?
My lord, petitioner's father got
No, this is target round.
with effect from 2021 to 2026. My lord, petitioner's father died on 27th of January 2023.
You have imputed the bank. ICICI Bank?
No. Yes, my lord.
Yes, sir.
Have you served?
Yes, I am, sir. All I have.
ব্যাংকে করেছি করে
তো ব্যাংকে করে রেখেছি।
ব্যাংকে
দেখতে পাচ্ছি কিনা কি
এক্সপেন্স করে কি দেবো না ও তো এক্সপেন্স করে দেবে
Yes, sir.
My lord, petitioner's father was died. After getting the license, mining lease, my lord, he invested huge amount of money in this said mining lease. My lord, he died on 27th of January 2023. My lord, thereafter, petitioner made a representation before the authority contract to consider his prayer as because he is the son of his deceased father.
His prayer for grant of lease.
Grant of this.
Where is your representation?
My lord, 58, 59.
You want to continue with the lease?
Yes.
Let it be
I not
considered.
consider.
My lord, in the meantime, my lord, I make one humble prayer before your lordship. My lord, all the apparatus are lying in this said mine area. My lord, your lordship can give and interim protection.
No, my lord.
No.
That can't be.
আমারটা আগে শোনো শোনো না
হয় না ওটুকুন দিতে পারবো না ভাই হয় না ওটা বললে তুমি বেশি বলে দিচ্ছ
all the apparatus shall remain in the petitioner's possession. Nothing else.
The leasehold property is already in your possession.
Yes.
So apparatus is lying there.
Yes, like
So no separate order is required. Deed has not been terminated. It will be considered within 1 month.
yes ma'am it will be considered within one by the respondent number 5 man
Yes.
প্রথমেই বোল্ড আউট
না না না
Unappears for the 8th
আরে আমি
respondent despite
সে তো দাও তুমি
paragraph. It is contended on behalf of the petitioner
আমি
that
চাইছি
the
যে আমার
petitioner's father,
এই করতে দাও সেই করতে দাও কিছু চাই
comma, since deceased, comma, was granted long-term mining lease.
বলে দিত
Three-day deed of lease executed on 30th October 2021 for a period of 5 years. Stop. The petitioner's father expired on 27th January 2023. Stop. The petitioner submitted a representation before the concerned authority
চলে যাবে আমাদের তো কথাটা করেছে
seeking permission to continue with the business of sand extraction
Lord,
as granted in terms of, yes,
can I
yes, sand extraction in terms of the deed of lease as granted, take it again, in terms of the deed of lease executed in favor of his father. Stop. The representation is yet to be considered. Stop. The petitioner prays for a direction upon the concerned authority to consider the representation at the earliest. Paragraph. Learned counsel for the respondents submits that the 5th respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the comma, the petition is disposed of, directing the 5th respondent to consider and dispose of the representation submitted by the petitioner dated such and such. Date বলেছি? No. No. ওটা তো lease-এর date. Representation 30th October 2023 dated ওখানে নেই ওখানে 30th submitted a representation যেখানে বলেছি ওখানে on 30th October 2023. নোটিশ করবেন না, লিজের ডেটও কিন্তু 30th October 2021. এটা 30th October 2023 representation date. Representation submitted by the petitioner dated such and such within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of, exactly. Yes, next one.
Item number 540.
Lord, 540, my lord, I am the petitioner.
Yes.
My lord, I have served upon all the respondents. Lord, the private respondent affected service. Lord, paragraph, page 10, 14, and 15, the track report. I have got this statement. There are 3 private respondents. My lord, this is, my lord, the suit property, my lord, is a recorded owner, the petitioner, my lord. My lord, it is just situated beside the PWD road and the ingress and egress of the said land through the PWD road. The private respondent, my lord, what happened? They have, my lord, made illegal construction on the PWD road, my lord, as a result of which the free ingress and egress is being hampered. My lord, admittedly, there is a civil suit filed by my client, my lord, on the ground that the private respondents are disturbing the peaceful possession towards the suit property. Accordingly, my lord, private property. Accordingly, my lord, an ad interim injunction restraining the private respondent was granted by the learned court below, my lord, and that is continuing. I have annexed, my lord.
Separate property.
That is separate. Here, my lord, because my lord, lordship knows, my lord, section 22 of the Highways Act, because civil court has no jurisdiction to. So, my lord, I am seeking only protection under section 10, my lord, the unauthorized construction on the PWD.
Yes, my lord, consider by page 24.
Yes.
Page 24, my representation.
Affidavit of service. None appears for the private respondents despite service. Paragraph, the petitioner claims to be the recorded owner of the plot in question and complains that the private respondents have raised unauthorized construction by encroaching upon a portion of the PWD road adjoining his property, thereby obstructing his egress and ingress. Stop, the petitioner submitted a representation before the concerned authority in this regard on 26 September 2023, which is yet to be considered. Stop, the petitioner pays for a direction upon the authority to consider the representation at the earliest. The paragraph, learned counsel for the state respondents submits that the 5th respondent be directed to consider the representation in accordance with law. 5th paragraph, in view of the above, the petition is disposed of, directing the 5th respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Disposed of, which chapter? Yes, another matter.
Item number 541.
My lord, this is my affidavit of service. The private respondents are received. I appear for the state, my lord. My lord, here what has happened, my lord? My lord, on the, my lord, Khodagpur Digha, my lord, road, my lord, it's not a highway, my lord, it's state. My lord, now, my lord, the private respondents have illegally, my lord, occupying and encroaching and occupying the road, my lord, and they are, my lord, running a factory, truck bodybuilding factory along with a dhaba. My lord, the entire ingress and egress of this petitioner's property, my lord, has been blocked by this, my lord, illegal occupants, my lord. My lord, now I have made one representation before the assistant engineer Khodagpur Highway. My lord, now he has informed.
PWD highway?
Yes, PWD.
State highway?
State highway. My lord, now he has informed me
by giving a letter, my lord, after filing of this writ petition. My lord, he has written that with reference to the above mentioned subject, this is to inform you that the road is not under the jurisdiction of this office. That is, my lord, the Kharagpur Highway Subdivision, PW Roads. My lord, the road is under jurisdiction of the Assistant Engineer, Kharagpur Subdivision. This has been ascertained after careful investigation of the location. So the authority concerned is the Assistant Engineer, Kharagpur Subdivision, PWD.
Not the Kharagpur
Highway Subdivision. So my lord,
Respondent number 3 needs to be
yes, ma'am.
amended.
So my lord, I am seeking leave to correct the
Make necessary correction to the cost title.
cost title and kindly, my lord, give me liberty to file a representation before this authority and let him consider my case, my lord, accordingly.
Let that be done.
And to initiate a proceedings under section 10 of the
Highways Act. Highways Act এ
Subdivision
authority তো section 10 এ
petitioners claim to be the recorded owners of the plot in question and complain that respondents have raised the case of the private respondents despite service. The evidence of service is important. And complain that the private respondents have raised unauthorized construction by encroaching upon a portion of PWD road adjoining their property, thereby obstructing their egress and ingress.
ওই জন্য বলি
The petitioners
ক্লেম যদি এর কাছে করো তাহলে এসডিওর কাছে সেটা হবে
seek to submit a comprehensive
এরা পার্টি আছে
representation in this
এগুলো দেখো
regard
পার্টি আছে কিনা
before the
ওই সাবডিভিশনাল
lead
অফিসার
respondent and pray for a direction upon the lead said respondent, to consider the representation at the earliest. Paragraph. In view of the above, the writ petition is
may I my lord, as per the Highways Act, my lord, the authority who is supposed to, my lord, consider this application supposingly means, my lord, it's a subdivisional officer, magistrate, subdivisional magistrate.
the assistant AG, not the subdivisional officer.
I stand corrected.
62
Under 60.
Subdivisional officer who deals with it.
I stand corrected.
It's the assistant AG.
I stand corrected. No,
In view of the above, the writ petition is disposed of with liberty to the petitioners to submit a comprehensive representation before the third respondent within 2 weeks.
my lord.
Within 2 weeks from date, stop, the third respondent is directed to consider and dispose of the representation within 3 months from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the petitioners and the private respondents, in accordance with law. শুরুতে করুন, on prayer of the petitioners, liberty is granted to correct the cause title of the writ petition.
But in the hearing, if it is found, my lord, there is illegal, my lord, encroachment,
Follow automatically.
kindly add that line. My lord, otherwise, my lord, he will
Line add করুন. In the event,
kindly add it.
in the event encroachment upon PWD road or any portion thereof is found, the concerned authority shall take necessary steps for removal of the same in accordance with law within the stipulated time frame.
And my lord, instead of 2 weeks, can it be 3 weeks, my lord, because the vacation is there.
শুরুতে representation within 3 weeks from date করুন। 2 weeks বলেছি। 3 weeks।
Deeply obliged.
Follow again।
Sorry, no.